2021. The DRT proceedings. Yes, Your Lordship. The urgency is that the DRT proceedings is at the stage of judgment. The court is not able to pass, the arguments have concluded the court is not able to pass the judgment because of the single bench order directing closure of the DRT proceedings. Because the single bench in its WP has directed closure of all proceedings, which would include this DRT proceedings. It has directed closure of the proceedings itself, Your Lordship.
Serial number 11.1. And but he's some funeral in his family. He's out of station, maybe taken up next week, minutes for the respondent.
In this, my lord, I appear for the appellants, my lord. Since, yesterday he told that his colleague's aunt has passed away.
11.1 minutes, Mr. Ashok. Yes. Yes.
Seal number 16, my lord. 16, my lord.
I'm appearing for the respondent caveat in this matter.
I prefer 10 days time, my lord. I need for some Lord, I need some instructions from the department, my lord, and there are some judgments, my lord. I'll have to go through it. 18, my lord. 18th, my lord. Sorry. Any date, please.
Please, ma'am.
Oblige, my lord.
Serial number 22, my lord, seeking for 2 weeks of adjournment.
That
Petitioner, my lord. Appellant. Only with respect to serial number 22, my lord.
May I make submission? May I make submission? Serial number 10. Kindly have it next week. Pardon me? Yes. Respondent, one.
Lord, I appear for respondent 2 to 7. On the last occasion, that is synopsis to be filed. There's no order to file.
Please.
2 weeks, your lordship.
Yeah, 14. Very good.
Okay, for respondent number 1 on this matter, my lord, it's a week's time, my lord, there's some compliance to be done. My lord, there's some personal inconvenience to the petitioner advocate. I'm a proxy counsel. There's some health issues right now. Yes, my lord, petitioner. My lord, there's health upset, my lord, she's not keeping well.
For the appellants in this matter, lordship.
Appear for respondent number 1, my lord.
For appellants, lordship, the matter has been settled between the parties, lordship, and some filing for memo of withdrawal of the appeal, lordship. Kindly permit me to withdraw the appeal, lordship. Yes, lordship. I was filed the memo on counter on 27/6/2024, lordship. One question. Yes, lordship. Yes, sir.
Yes, no, respondent number 1, my lord. Karnataka State Financial Corporation.
The mainly dispute between the appellant and respondent number 1, lordship. They are settled down. Yes, lordship. Respondent number 1 is the contesting party. Grateful.
Much. May I please, my lords?
It's I appear for the appellant's counsel. It's matter lies in a very narrow campus. We have filed our submissions as well. So if your lordship. The issue is, my lords, the validity of the ordinance was questioned by the petitioners after taking the examination, contending that the ordinance is not in tune with the MCI regulations. The university considered that position. Ordinance to appoint the evaluators for the examination. He had participated, the examination was conducted. The university considered that the ordinance was in variance with the MCI regulations. However, it pointed out that in fact, the examiners who were appointed were in tune with the MCI regulations, and it was in the process of amending the ordinance. And later, in fact, the ordinance was made. So no prejudice had been caused to the petitioners. However, the learned single judge has allowed the writ petition, holding that since it was in variance and the university is refusing to show to the petitioner the persons who had evaluated, who the university contended were fully qualified and in tune with the MCI regulations, allows the writ petition, quashing the ordinance. The university has no difficulty with quashing because it has reenacted an ordinance in tune with the MCI, but has directed that re-examination be conducted without court recording that any prejudice has caused. In fact, my lords, when we made an all the part, yes, my lord. It would be everyone because ordinance was held to be bad. Now, my lords, even before the learned single judge, we offered to place before the court in a sealed cover the examiners who had evaluated, who were fully qualified in terms of MCI. That, lords, the court has not dealt with. Lords, when the matter came up before division bench, when the matter came up before the division bench noticed in the sealed cover that they were all fully qualified. Lords, could I request my lords to kindly see the order sheet in writ appeal dated 23/4/2021. The order sheet, my lords.
Yes, my lords. Respondents 1 to 16. Please, my lords.
Very well. Very well. University has filed. Both are common. The issue is same. Only issue is whether it has caused any prejudice to the same order. Lords should have it in the afternoon. Lords.
Appearing for appellant, madam.
R1 is state government. R4 is a private respondent.
We need to take steps, madam.
There is a order of status quo, my lord, was to be.
Respondent number 1.
Resolved. Sixty-three of 22. Not in 336, it is in the 63 of 2022. It is in the 63, I am for the appellant in 63. And representing third respondent in the first matter. Please. Status quo is there, my lord. It is, please, very well, grateful to you.
During the course of the day, I will take steps. 2.
Entry model ಇದೆಯಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
I appear for the appellant in this matter.
Lord, sir.
This will have to be heard, Lord, because this is a substantive challenge to an order of the learned single judge. Final order quashing acquisition with respect to one property.
Lords, there are 2 writ appeals, one by the state and the other one by the BDA. Lords, the memo is filed. The reason is this. There is a scheme by this Bangalore Development Authority called as the BTM third stage layout, 6th stage layout. Lords, pertaining to the 6th stage, there are at least 4 times, Lords, the BDA has approached this honorable court, the division bench of this honorable court, against the orders passed by the learned single judges, where it has already been held that the scheme is lapsed and the BDA cannot implement the scheme. One was withdrawn, one was permitted to be dismissed for non-prosecution. 2 are decided on merits, where this honorable court, the coordinate bench, has taken the view that BTM third stage layout cannot be implemented, 6th stage layout cannot be implemented. One of which was taken to the Supreme Court, and the Supreme Court has dismissed the SLP. It is in this background, Lords, we have come before this honorable court. And I'm in a position to produce a series of orders where the BDA is very selective, Lords, in coming before the court. There are at least about 20 petitions in which the BTM 6th stage layout was challenged before the learned single judges, and all those petitions have been allowed by holding that the scheme is lapsed. Writ appeal is filed in selectively in 3 or 4 of them, out of which 4 is disposed, 1 is pending now. This is the only one which is pending. So far as the state is concerned, the state said that notwithstanding that we have not implemented the scheme or formed any layout, but we wanted the BDA to allot this as a civic community for the purpose of a police station. Now, the government has now allocated an alternative land to the police station, which the police have accepted. So that part of the order, Lords, acquisition, Lords, was for a larger scheme. But the BDA, what it said is, all right, we cannot implement the scheme, but whatever is there, we will give it for other public purposes. This is the manner in which the BDA portrayed it before the learned single judge, in the teeth of an order having been passed saying that this property should be given to the police station. Now, the change of circumstance which I have now placed is the police station, my lords, is now relocated. They have been already given with an alternative land. So the state's appeal would not survive.
Unfortunately.
That's the only ground on which the state.
This is a
Very well, my lords.
But of course, I don't know if, which particular order my learned friend speaks of, but this is the third round of litigation. The challenge to the acquisition has been rejected by this court earlier. And all of a sudden it comes up. Now, learned single judge says you must treat this like a suit for injunction. You can keep filing fresh petitions after every dismissal. In my respectful submission, Lord, that may run counter to the principle res judicata, because that question was raised, question was answered, and after it is answered, now another petition is filed. Learned single judge holds that though there was a petition filed earlier and the petition is dismissed, I will reconsider the entire issue and examine it to see as to whether the acquisition is proper or not. As a matter of fact, Lord, the finding on possession is actually admitted by them, because they said we've come and demolished the building. If I've demolished the building, Lord, it obviously means that I've taken possession of the property. Now, after compensation has been deposited in the civil court. Long back. And this is completely a new argument being advanced for the first time now. And your lordships know, Lord, even if the scheme, they argue the scheme has lapsed, but the findings in every order that at least they produce before your lordships now is that with respect to a particular survey number, the scheme has lapsed because possession was not taken. But in this case, that issue does not arise. And I can utilize the property for, my lord, if I don't use it for the same purpose, your lordships know, my lord. In acquisition, state can always use it for another purpose. That so long as it is a public purpose. And therefore, today, my lord, this is really trying to do post-mortem on something, which is really, in my humble submission, completely put an end to.
Lordships. Because the BDA wanted to go, Lords, this is the reason why the learned single judge said that the learned single judge framed points for consideration. One of the points for consideration is as to whether the earlier writ petition which had been filed comes in the way of considering the instant writ petition. The learned single judge takes into account there are multiple orders which are already passed pertaining to this very scheme, where it is said that the scheme is already lapsed. And then the next question is framed whether it would operate as a rem, because the lapsing of a scheme, whether the entirety of the acquisition would stand affected. There, the learned single judge says that if a scheme is implemented for a substantial part or a part of it, then even if it is declared by the courts that the scheme is lapsed by applying Section 27 of the BDA Act, it would apply only to the extent of those portions where the scheme is not implemented. So it is not in rem in substance, but wherever it is not substantially implemented, then thereafterwards it is applicable. Third question was as to whether the possession has been taken. The learned single judge goes in detail. It's a factual the finding of fact by the learned single judge saying that though this is the margin drawn and this is the manner in which you claim the possession is taken, factually there is nothing to indicate that the possession has been taken. So therefore they cannot now come and say. There is a point beyond this. Not despite the possession having been taken, whether the BDA can still hold these island pockets was considered by the Honorable Supreme Court in Bondu Ramaswamy's case, where it said that you cannot pick and choose 5 kuntas, 10 kuntas, 3 kuntas out of 1,000 acres saying that we want to form an isolated pocket of a public utility development in this pocket. What is held good for the 1,000 acres cannot be refused for a 3 acres person. That's how, my lords. So therefore, I'll put on record, my lords, as your lordship suggested, my lords, Lordships, 1 week, my lords, I am. Lordships.
2 weeks.
A date may be fixed after 2 weeks, subject to lordships. Lordships. Please.
31.
Please, my lords.
Good. Great.
For the appellant in serial number 7, my lords, the amended cost title is ready. I file it through the course of the day.
I am for the respondent 2, 4 and 6 to 11, my lords.
The legal representatives of respondent number 3 and 5 were brought on record. And I had to carry out the amendment. The amended cost title is ready, my lords. I may be permitted to carry out the amended through the course of the day.
Next week, date may be fixed, my lords. Yes.
I may be permitted to carry out the amendment, my lord. Please, wait.
Date, my lords. Next week, my lords, because senior citizens, your lordship kindly say 1964 notification quashed by the learned single judge.
Grateful. my lords.
The particular date may be fixed in first. Yes, yes, much.
My lord, I'm first responding, my lord. First responding.
My lord, your lordships will recollect, this is regarding the excess pension matter, my lords. I've sought instructions. Please, my lords, I'm filing it in the form of an affidavit. I may be permitted to hand it across. Lords, may I draw your lordship's kind attention? Please, my lords, only the principal amount. I have produced a calculation of the excess pension that has been paid from November 2011. Please, my lords, thereafter there have been some more payments which inadvertently were not in the IA. I've made an amendment to that effect here also. And I've produced the, my lords, the amount right now is 3,29,787.
My lord, because of the negligence of the respondent authorities, my lord, they have filed as so the recording interest rate imposed, other expense exposed, but I'm restricted to only the principal amount, my lord. Since I'm the age-old pension holder, just meager amount I'm getting, my lord. But yes, so going to 3,20,000, it goes to the entire amount, my lord. Yes, so without interest, may impose, my lord, in recovery, my lord. Please, my lord, excess. Without interest, my lord, it is.
My lords, please, my lords, I'm
Please, my lord.
willing to consider.
Please, please. My lord, without interest, my lord, it is. Without interest.
Please, my lords, I have said that in my affidavit myself at page 2. That
Please,
this
my
is
lord.
without any interest or other charges.
Please, my lord. Family pension. Please, my lord. Well, my lord, earlier, my lord, is only principal amount of 50,000, my lord. 50,000. Please, my lord. 234,158. But the multiplying is interest rate, my lord, that's why, my lord. My lord, in the meanwhile,
And they've also given the bank statements to compare that this amount has actually been paid. My lord, kindly see, my lord, your lordships will find a difference amount under the column due. The middle column is due. Please, my lords.
two thousand and 17 minutes. Please. Modification, modifying the order, my lord, your single case. The setting aside means, please, modifying.
My lords, in my humble submission, my lords, it would have to be set aside. Please, my lords. My lords. My lords, my only submission is, my lord, suppose they don't pay any installment or they don't agree, then I will be put. Please, my lords, therefore I'm requesting that your lordship set out the installments in the order itself, my lords. 329,787, if they're willing to pay 10,000 every month. My lords, the monthly pension that she is.
2,000 and odd, my lord, it is. 2,000 and odd, my lord, is. The meager amount comes to, my lord.
My lord, the pension that was paid till June 21 was 9,456. It was in 2021, June 21. That's the last amount on page 5. So how much is the pension now? Please, my lords. Please. Please, my lords, I'll bow down to any order, my lords. It's just that, my lord, she, in my humble submission, she also has other sources of income. She has another account in our bank where she's getting rental income, etc. But therefore, my lords, I would never want to render her destitute in recovering this.
4 months, then again put into financial crisis, my lord, because I'm aged lady, it is put to 5,000, it goes to the entire portion towards the penalty amount regarding rights, recovering. Therefore, my lord, the shall come to the, please.
Very well, very well.
Great.
Two. Two.
Second. No issue. My lord, please. 94 minutes.
Yes, ma'am.
Please, madam.
I'm deeply deep.
Please, madam, or you should the copy, madam.
Please, ma'am. I'm great.
I'm for the appellants, my lord. Two IS have been filed for bringing on record LRs of R2 and LRs of appellant number 1, which is pending consideration.
Six minutes.
In the ocular, I have not filed the wakalat, just I filed the application for yes, my lord, I'll file on the next date of hearing. I'll file on the next date of, because Yes, sir. But yes, my lord. Yes, ma'am. I'll do that. Yes, ma'am. My lord, on my humble submission, there was a interim order in the inception. Previous 2 dates, the matter was not, did not reach. Hence, the same has not been continued. Last, it was 8/9/22. Till that time, it was there. Yes. 17/4, it did not reach on that day, my lord. 17/4 and 15/12, 2 dates it did not reach. The matter was not.
Milords, in this case, I'm appearing for appellant, Milords. Milords, I pray for a week times. Yes, Milords, Milords, we were unable to contact the trial court advocate, Milords. Like we could tried contacting him, but his phone was not reachable. So. Milords? Milords, the instruction we had to seek was whether they are staying together, Milords. Whether the appellant and the respondent are staying together, Milords. We had to seek instruction regarding that. We were unable to take the instruction. So a week time may be granted. Date may be fixed, Milords. Obliged. Obliged.
Not serial number 13, not sir. I request for a week's accommodation. Not he wants, appellants want to engage a senior counsel. Senior counsel engagement. Lord, revenue authorities initially they reject my lord entry in favor of respondent number 4 by a order telling that there is a civil suit is pending. When petty appellants approach my lords to change the entries in favor of respondent number 6, they enter the name of respondent number 4, contrary to their order. Single judge says you have alternative remedy. That's the only point to be addressed. Not a senior counsel requirement is there, my lords. Not remedy, my lords, no doubt, my lords. Now our grievous contention is when the Tahsildar himself has passed the order telling that the sale deed is void and civil suit is pending, will not enter your name. He passes that order. And in the second round, when the appellant goes and requests for change of entry in favor of respondent number 6, subsequent purchaser, they don't enter the name of the subsequent purchaser name based on the registered sale deed, but they go and enter the name of the respondent number 4, wherein there is already an order not to enter his name. And the same officer says, passes an order that you not enter the name of respondent number 4. In subsequent proceedings, he couldn't have entered the name of respondent number 4. That is the only not that point, that's the reason, senior. Please. Try to convince the court. Please. Yes, please. No, not sir. Clients, they have instruction or they want to engage. That's the reason. Today we couldn't engage. That's the reason. Please wait. Wait.
Appearing for appellants, my lords. Phrase 2 days time, my lord. Senior is not well. Press 2 days time, my lords. The senior is not well, my lords. It's 2 days time. Senior is not well, my lords.
Or in the next week, it may be listed. I am for respondent, my lord. Yes, my lord.
There is,
No, I am ready from the day one.
there is 43 days delay, my lords. Delay may be condoned. There is 43 days delay, my lords. Delay may be condoned. Much obliged.
For the appellant one. There is a 30 days delay in the filing the appeal, madam.
I have no objection for condoning the delay, the lordship.
This is the appeal, my lord, the filed by the authority, my lord, on the rejection, the cancellation of the rejection of the bail, the auction, my lord.
Yes.
Next week, my lords may fix it. Next week for final disposal, my lords may fix it. We will argue on it. There's subsequent development. My lord. What has happened is, this, my lord. After the order was passed by this honorable court, there was no stay. There was no stay order. Then notice came to me, I appeared. In the meantime, I also gave letters to them to execute the sale deed in terms of the order of this honorable court. They are not. What they have done is they have auctioned the same property again and sold it to somebody else. They have created third-party rights. And what happened is in January, suddenly somebody came and started digging a borewell. Immediately I came to know, I got a police complaint issued. The work has stopped. What I would request your lordships is, let the status quo be ordered now. And then, no, he has not come on record here.
Yeah, yes, my lord, I will get.
Even before, my lord, I would like to say this, my lord, even before it was notified, immediately I brought to the notice of the Commissioner BDA, since there is already an order earmarking this site for me by virtue of this order. Please do not take any prescriptive action. Nonetheless, my lord, they put it for auction, then sold it, executed sale deed, everything is done by them. And I have filed a contempt petition before this honorable court, bringing it to knowledge of the division bench that they have committed contempt. How could they sell a property which is already decided to be? Unless there was a stay order, my lord, that order is set aside. But
I will get the instruction, my lord.
yes, my lord, yes. Let the status quo be continued, my lord. Otherwise, my lord, if somebody else were to do that, so they have sought for stay of the impugned order. Yes, ma'am. I think they should put the clock back, my lord, now. They should put the clock back. Your lordships may fix it next week itself, my lord. My lords may fix it on 10th or 11th, my lord, we will. Grateful. Obligement. My apprehension is this, my lord. My lords may consider. My apprehension is if some activity goes on there, my lord, it will lead to. Yes, my lord. I'll make necessary. I understand, my lord. I understand. I understand the situation, my lord. Grateful to your lordship.
My lords. My lords, I appear for. My lords, I appear for the appellant. Pray for 1 week's time.
17. Already applications have been disposed of, my lord. It may be posted for final hearing. This honorable court allowed the additional documents application.
My lords, pray for a week's time. We'll argue it on the next week. We'll argue it on the next week, my lords. 1 week time. my lords.
KHP.
Yes, my lords.
Three lands have been acquired, my lord. For three portion of the land is concerned, one preliminary notification is not issued, final notification was issued. And another one is the land was not taken the possession and award is also not deposited. And third part of the portion of the property is concerned, no preliminary notification and no final notification. That is why the repetition was allowed, my lord. Compensation was given for only one property where the preliminary notification was not given. And another two properties, no compensation was deposited, no possession was taken. That they were only the Annexure C may kindly be pressed. We directly they have issued the final notification as far as the 22/2B is concerned, without giving the preliminary notification. That is the, yes. That is how the writ petition was allowed. The basic thing is reissuing the preliminary notification in respect of survey number 22/2B is concerned. That was not done by the KHB. My lord may kindly see the page number 30, ink page 30. Single bench order. (22/2B), 22/3, and 22/4. Possession was not taken to any of the property. 22/2B. Yes, my lord. Because no preliminary notification was given. No preliminary notification was given in respect of the 22/2B is concerned. Straight away, they have given the final notification. That is the dispute.
My lords, there's also an interim order. What's up?
My lord, I appear for the appellant in this matter. My lords, this is an appeal from the order of the learned single judge, wherein the learned single judge rejected my claim for insurance for having multiple sclerosis on a finding that I have not disclosed. The appellant, my lords, had entered into an insurance policy. My lords, I may take my lords. This is at page 132, my lords.
I'm for the respondent. He is representing Ombudsman. So for respondent number 2 is concerned, the state will not appear for respondent number 2. My lord. In the petition also we have not appeared. Respondent number 2, my lord, showing this government to look at, but we are not appearing for respondent number 2, my lord. Central government standing counsel will come. This, Ombudsman. Even in the one. Respondent one. Even the petition also we are not appearing.
Wow. My lords, the parties are, respondent 1 is the insurance ombudsman. Both parties are same. What is the correct thing? Who's HDFC? R1 is the insurance ombudsman, my lords, because the ombudsman had finally rejected my claim for me for insurance. And R2 is HDFC.
ನಿಮ್ಗೂ ಬಂದಿದೆಯಾ? Minister.
Yes.
Please.
Yes, yes. Yes, my lords may kindly see the insurance policy. This is at page 132, my lords. Something. Page 132. This is the insurance policy. Yes, and my lords may see, this is dated 29/4/2017 at the right corner, just below HDFC Ergo. And my lords may just see the center title. It's a Home Suraksha Plus. The petition, the appellant and her husband, the insured's name are two, my lords, Woman Pranash and Mrs. Elizabeth Matthew Jaya. The couple, my lords, in fact, had taken a home loan. As part of the home loan, this was a Home Suraksha Plus policy. This was a home insurance policy. And this was the policy they gave me when I was taking a home loan. As part of the home loan, kindly see the coverage details. It included fire, building, burglary, etc. And on the right at number 3, medical illness as well. It was in principle not a medical policy. It was a home loan insurance policy. Now, when this policy was taken, the claim I later on, my lords, got diagnosed with multiple sclerosis. Since this policy covers illnesses as well, I then went to claim under this. When I went to claim under this, the insurance rejected my claim, saying that you have not disclosed. Now, my lords, kindly see when Yes, there is no dispute. According to them, I was aware that I had multiple sclerosis and I have not disclosed. My claim is that I was never diagnosed with multiple sclerosis as on the date of the insurance policy. So I was not aware that I had it. There's no question of disclosure. And I'll show my lords the where I have entered it. Is that page where the blank column is there? Yes, my lords. Yes. Yes, my lords, and then I will show. Yes, now I'll take my lords to the order, my lords. Yes, yes, my lords, the order is at page 45. And the relevant reasons, my lords, are at page 53 onwards. And then I will show, my lords, after I read out the order, I will show the documents that the order relies on. My lords, at page 53. Yes. The order states the last 3-4 lines. The policy does contain, my lords found that, the policy does contain coverage of major medical illness and procedures. The policy directed the petitioners to tick appropriate conditions in case the person proposed for insurance has been diagnosed or is suffering from any symptoms or has undergone any of the below medical conditions. The clauses of the policy which are relevant are as follows. And there was a box there with all the different medical conditions. In that box, my lords, in that chart which the judgment has reproduced, multiple sclerosis is also there. I have not ticked anything. I continue to read, my lords. One of the aforementioned columns related to multiple sclerosis. The aforequoted were the conditions of the policy. The first petitioner on 10/8/2020, my lords, kindly note, the judgment also admits that on 10/8/2020, I developed symptoms. This is much after the policy that were again becoming a problem with the central nervous system and was admitted to Vikram Hospital. The doctors at Vikram Hospital diagnosed the problem to be multiple sclerosis. And I have my medical records. And thereafter, my lords, I'll just skip a few pages. And finally, the impugned judgment goes on to state, my lords, at page 70. At page 70, my lords.
29/4/2017.
29/4/2017. And then, my lords, page 70. Yes, my lords. Yes, paragraph 11, my lords. On a coalesce of the judgments rendered by the Apex Court and that of the Bombay High Court, the unmistakable inference would be that the Mediclaim policy, being a non-life insurance policy, is a contract of insurance falling in the category of a contract Uberrimae fidei, which would mean the contract of utmost good faith on the part of the assured. Divulging pre-existing illness was a duty of the insured. Having not done so, the repudiation of the claim cannot be found fault with in the teeth of the preceding analysis. Insofar as judgments relied on by the learned counsel for petitioners, they are all distinguishable without much ado. So and so, my lords, yes. Yes. Now, my lords, I will take my lords. The claim is that I have withheld and not disclosed. Now, my lords, I will show my lords. There were some documents where I have gone to, and that is the basis on which the insurance rejected. Now, my lords, kindly see at page 118. Page 118. This is a report of Columbia Asia Hospital. 118. And my lords, the date, these are some reports before the policy. So I want to clear that. Now, this is on 27/3/2017, before the policy. My lords, I had certain medical conditions. I went to the hospital, and the findings, my lords, kindly see in the findings is given cerebral parenchyma, hypertension, ovoid lesion in so-and-so aspect of the upper pons, no restriction on DW1 blooming. On the contrast study, lesion demonstrates enhancement, few other hypertension lesions without any post-contrast enhancement. So this was the diagnosis given. Thereafter, and in fact, on the next page, there are some findings on what the examination posted. So, and finally, my lords, on page 120, this is the same report, page 120, the final finding, impression. My lords have found that impression, 33-year-old female with headache, severe dizziness with multiple episodes of vomiting, more on change of position of head since 1 week. Because I was getting vomiting, I went to the to get an examination, which aggravated since 2 days back. MR brain with 4 contrast and MR head, they did a scan with the neck angiography, and they say that there are lesions. Thereafter, so there is nothing related. Then, my lords, there is, sorry, one more page. Kindly see the next page, 121. 121, under that table, they say sulcal flare hyperintensity is noted. Angiography and venogram is unremarkable. Features could be possible of demyelinating etiology like multiple sclerosis, less likely to be infective etiology. Advise comparison with prior imaging if available. Recommend clinical correlation and further evaluation. After this, I was asked to get some more tests. I go to another hospital in 3 days. That is at page 108. This is Bangalore Baptist Hospital at page 108, my lords. (108) Yes. This is on 30th March 2017. Diagnosis. My lords, kindly see the diagnosis. I go for some more tests. Diagnosis, vertigo. Acute vertigo. My lords found that. Acute vertigo, white matter disease of CNS. And course in the hospital. The same page at the bottom, my lords. Course in the hospital. Mrs. Jaya was admitted with the above complaints. Initial differential considered were vertigo or posterior circulation stroke. She was started on symptomatic treatment with beta histines. MRI done outside showed T2 hyperintense lesion in the medial aspect of upper pons. And my lords, in bracket with the question mark, it says multiple sclerosis. My lords could observe that. At the bottom of the page, there's a question mark. There's a question mark which they themselves have put a question mark, which means, is it? Then the report continues on the next page. Neurology opinion was advised and was advised EEG, NCV, so-and-so. 2D echo done was normal. ENT consult was sought and was advised conservative management. Her vitals, sugar, urine output were regularly monitored. She improved with the above care and is being discharged in a stable condition with the following advice. Condition at discharge symptomatically better, so-and-so, and to review, etc. Thereafter, after 1 month, I have been discharged after this examination with a bracket saying question mark multiple sclerosis. There is no diagnosis given, nor am I told that you have to take treatment. Thereafter, after a month, I go for one more consultation at page 124. At page 124 to Malya Hospital. This is, my lords, on 18/4/2017 at page 124. Yes. My lords have found that? Yes. This is on 18.4. All here the doctor's notes are vertigo investigated. All along, I have been told that I have vertigo. My lords, page 124, my lords, since my brother judge has, yes. Vertigo investigated extensively at both Columbia and Baptist. And in fact, they reproduced what Baptist said. Baptist said question mark multiple sclerosis. It is just reproduced. It says now much better. ENT is normal, reassured, review SOS. Means they said you review whenever there is a crisis. That's it. So when I signed the insurance policy, these were the diagnoses I have got. I had been having dizziness and nausea. I went to 3 places. I have not got any finding that this is MS, nor have I even been started on any treatment. The only finding I get, my lords, is at page 159, which is a confirmed finding in 2020, which is at page 159. And that is when I make the insurance claim. For 3 years, I don't even make a claim because I'm not suffering from the illness. I don't need medical treatment. If I had it, then immediately afterwards, I would be undergoing intense medical treatment. I didn't even undergo any treatment. At page 159, my lords. This is when I was admitted. This is, my lords, 18/9/2020. I'm admitted to Vikram Hospital. And there the diagnosis, my lords, may kindly see relapsing, remitting multiple sclerosis. A clear diagnosis is given that it is relapsing, remitting is a kind of multiple sclerosis. So for the first time, it has been stated the Jaya Matthew 36 is a case of relapsing, remitting multiple sclerosis. And even course in the hospital says that this is a case of RRMS. This is a kind of multiple sclerosis, admitted for injections. She received injections, etc. And after standard pre-medications, and then there's an advice on discharge. I have been given all treatment and medication advice. And that is my advice given with regular OPD, with regular checkups. And it is only after this in 2020, when I'm diagnosed with multiple sclerosis, my lords, I make a claim. When I make a claim, when I first make a claim, the respondent to insurance company at page 168, they reject my claim. And that is at page 168. Page 168, if my lords can see. This is the letter of the insurance company. My lords, the third para, if I may read out. We would like to draw your attention that your claim has been declined due to the above mentioned reason, which is the basis for disallowing the claim, and extract of which is mentioned below for your ready reference. As per the documents received and verification, it was diagnosed to be, the insured was diagnosed to be suffering from multiple sclerosis since 27/3/2017. They go to those records of mine because I have never I have never withheld those records. As the claim, I'm sorry. No. No, no. No. No, no. I have. Yes. No, in fact, kindly see the insurance policy, my lords. Yes, kindly see page 125. I was never asked. Yeah, it's a full form. My lords, kindly see page 125, if I'm right. Yes, page 125.
Proposal
Page
form.
125
Proposal form.
is the proposal form. it's a little hazy, but it has, my lords, a chart. It has a, yes, my lords may open up, it has a chart, and it has many medical conditions, hypertension, diabetes, cancer, stroke, multiple sclerosis, etc. I have not ticked any of them because there was yes, my lords, just kindly tick the appropriate condition in case the person proposed for insurance has been diagnosed to be suffering from any of the symptoms and has undergone treatment. So I have neither undergone treatment for multiple sclerosis on that date. I was given no treatment for multiple sclerosis, nor have I undergone any symptoms. I had undergone symptoms for headache, dizziness. I was given some tests, and I was discharged. And in fact, the insurance policy says what is pre-existing condition. It's part of the policy rules. And that, my lords, is at page 139, which is also part of the policy. Yes. Page 139, clause 38, pre-existing. Yes, may I read out? Pre-existing means any condition, ailment or injury or related conditions for which you had signs or symptoms and or were diagnosed and or received medical advice, treatment within 46 months prior to our first policy with us. That is the requirement of what is pre-existing. And in the situation of multiple sclerosis, in fact, there's a specific reference at page 143. I'm sorry, page 143, section 3. Speaks about major medical illness and procedures, insured event. For the purpose of this section, the determination of the company's liability, the insured event in relation to the insured shall mean any illness, medical event, or surgical procedure, or as specified below, whose signs or symptoms first commence more than 90 days after the commencement of the insurance policy. That is, if you're covered after it, and that includes cancer, etc., multiple sclerosis. So my diagnosis commenced after the insurance policy was executed. I had what the learned single judge, in fact, has mentioned that question mark multiple sclerosis written in brackets means you were aware that you had multiple sclerosis, you have not disclosed. I would like to just give one decision on the point, my lords, that I can end there. The learned single judge has given a finding that going by those 3 reports prior, which I referred to, my lords, the question mark multiple sclerosis, which was in brackets, means it was actually a finding of multiple sclerosis, which I have withheld. Let me read out that provision. Let me read out what where that reference is made, my lords. Yes, page 53. Page 53. Page 53, about the 5th or 6th line. Therefore, the first petitioner, what the learned single judge holds, therefore, the first petitioner was thus diagnosed with a symptomatic attached to multiple sclerosis, even in terms of the opinion, though it is bracketed. Nonetheless, it was found. Therefore, there was a doubt in the mind of the doctors that it could be multiple sclerosis as it was attached to the central nervous system. Discharge was made on 30/3/2017 after about 3 days of the petitioner being an inpatient, etc. Now, my lords, even these two sentences, if I may be with great respect submit, both sentences are actually contradictory. On one hand, the learned single judge says that even though it is bracketed, nonetheless it was found. Though there was a doubt in the minds of the doctors, therefore there was a doubt in the mind of the doctor that it could be multiple sclerosis. If there is a doubt, then how can it be found to be multiple sclerosis? The fact that there was a question mark and I was not prescribed any treatment for it, there is no diagnosis saying this is multiple sclerosis. If the doctors at any of the 3 hospitals has said this is MS, that ends the matter. There is no doubt. The only time I got this diagnosis was in 2020. This is recurring multiple sclerosis. We are not, my lords, medical experts to diagnose or to investigate all the written reports of the doctors and come to a deduction. So she was never even told by the doctors that you have MS. And in fact, there's a recent judgment of the Honorable Supreme Court. It is, my lords, it is, with great respect, it is. My lords, I think learned single judge has just taken it out from the medical reports. 139, my lords. Yes, my lords. No, my submission is that the learned single judge has not taken it from the policy. Yes. Yes. For which you had signs or symptoms. Symptoms, yes. Were diagnosed. Yes. Yes. Prior to your policy. Yes. 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 The learned single judge, the language used that I was diagnosed with a symptomatic attached to multiple sclerosis is taken, in my humble opinion, from page 108, which is the Bangalore Baptist Hospital report. Page 108, those exact words are used. Kindly may I read out the last 2 lines of page 108, where the doctors say she was started on symptomatic treatment with beta histines. MRI done outside showed T2 hyperintense lesion in the medial medial aspect of upper pons, bracket, question mark, multiple sclerosis. So the learned single judge makes a deduction, according to me, that she was started on symptomatic treatment of multiple sclerosis. That is my humble submission, my lord, is incorrect. If I was having multiple sclerosis, the report would have said, yes, you have it, like my final report. No treatment was given. In fact, for 3 years after it, I never went to the hospital. And when I applied for this insurance, I myself disclosed all these reports. 38, the pre-existing. Yes, what is pre-existing? Pre-existing, my lords, means, I would like to read it again, mean any condition, ailment or injury or related conditions for which you had signs or symptoms and or were diagnosed. Sorry. Signs or symptoms and or yes. And 24 distributed advice of treatment. In 48 months prior to yes. 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 They have not, in fact, gone into this. My contention, my lords, if we read pre-existing along with page 144, I missed out referring to that. May I just take my lords for a moment? Yes. Yes, and the reason I'm saying that, my lords, is my version is bolstered by page 144. Continuation. Kindly, may I refer to that? I missed out referring to that. Page 144, on the right-hand column, multiple sclerosis. In fact, each of the illnesses, cancer, diabetes, etc., my lords, kindly see multiple sclerosis with persistent symptoms. The definite occurrence of multiple sclerosis, the diagnosis must be supported by all of the following. Investigation, including typical MRI and CSE findings, which unequivocally confirm the diagnosis to be multiple sclerosis. There must be current clinical impairment of motor or sensory function, which must have persisted by a continuous period of at least 6 months. Well-documented clinical history of exacerbations and remissions of symptoms or neurological deficits with 2 clinically documented episodes, other causes of neurological damage. Now, my lords, there needs to therefore be unequivocal diagnosis to be MS. Pre-existing, yes, my lords are right. We have to read pre-existing with this. But the signs and symptoms or diagnosis should be unequivocal. Even if I have symptoms, it should be of the motor neural degeneration, which are unequivocally related to this. Today, I may have some vertigo. I went with vertigo-related symptoms. Vertigo can be for any illness, but that link to my symptoms to that illness has to be made. I am not a doctor to make that link. When the doctors give me a report with all kinds of question marks, don't put me on any treatment for it. Am I, as a person, expected to read into it? I'm not expected to read. And in fact, the Honorable Supreme Court, in only one decision I want to submit, that where a column is left blank in an insurance policy, it cannot be said that you have withheld. If they have a doubt, they may have to specifically ask you again. But that cannot mean that I have withheld or I have misrepresented. And that cannot be a ground for rejecting my claim. That one decision I'll submit. Yeah. And the learned single judge has moved on the proceeding that in insurance policies as utmost good faith. Yes, utmost good faith principle is there. But it's not just a only principle of utmost good faith. Can only be if I'm aware of that information. Yes. My lords, this is 2022 for SCC 582. And the relevant portions. In fact, here also the person had a heart condition and which was not disclosed. And I will take my lords to the relevant para. Yes. Page 19, my lords. Page 19, para 39.3. The materiality yes, 39.3. The materiality of a particular fact is determined by the circumstances of each case and is a question of fact. If a fact, although material, is one which the proposer did not and could not in the particular circumstances have been expected to know, or if its materiality would not have been apparent to a reasonable man, his failure to disclose is not a breach of his duty. Full disclosure must be made of all relevant facts and matters that have occurred up to the time at which there is a concluded contract. It follows from this principle that the materiality of a particular fact is determined by the circumstances existing at the time when it ought to have been disclosed and not by the events which subsequently transpire. Then they go on to the duty to disclose. And then on the same page, next page at para 43.4, they say, where the space for an answer is left blank, leaving the question unanswered, the reasonable inference may be that there is nothing to enter as an answer. If in fact there is something to enter as an answer, the insurers are misled in that their reasonable inference is belied. It will then be a matter of construction whether this is a mere non-disclosure, the proposer having made no positive statement at all, or whether in substance he is to be regarded as having asserted that there is in fact nothing to state. Where an answer is unsatisfactory, as being on the face of it incomplete or inconsistent, the insurers may, as reasonable men, be regarded as put on inquiry so that they may issue a policy without any further inquiry. They are assumed to have waived any further information. So the court says that if you want anything specific, you ask. If not, it is deemed to have been waived. However, having regard to the inference mentioned in head 43.4 above, the mere leaving of a blank space will not be normally be regarded as sufficient to put the insurers on inquiry. Then, my lord, these are general principles. Then specifically, the Honorable Court goes on to state at para 52.5, they make two references to two decisions. Yes. 52.5, bottom of the page, my lords. Yes. In LIC versus GN Channabasamma, it was observed that there is an obligation upon the insured to disclose all material facts which may be relevant to the insurer. But after issuing a policy, the burden of proving that the insured had made false representations and suppressed material facts is on the insurer. In the said case, it was held that the physician's statement did not lead to a conclusion that the respondent therein was influenced by a serious disease for a long time. On consideration of the evidence led by the parties therein, it was observed that the insurer had failed to prove that the insured was suffering from diabetes or tuberculosis at the time of filling up of the proposals for the policies, or that he had given any false answer in his statements or suppressed any material fact which he was under a duty to disclose. Then 52.6, in Canara Bank versus United India Assurance, is a case in which this court held that if a column is left blank, the insurance company should ask the insured to fill up the column. If the insurance company, while accepting the proposal form, does not ask the insured to clarify any ambiguity, then the insurance company, after accepting the premium, cannot urge that there was a wrong declaration made by the insured. Leaving a column blank does not mean that there was a misdescription of facts. To make a contract void, the non-disclosure should be of some very material fact. Therefore, the insurer therein was directed to indemnify the insured. Thereafter, in this case, the Honorable Supreme Court gives finally a finding at page 50, at para 55.4. And in fact, the whole principle is on this duty to disclose, which the learned single judge has relied on. 55.4 minus. If any query or column in a proposed form is left blank, then the insurance company must ask the insured to fill it up. If in spite of any column being left blank, the insurance company accepts the premium and issues a policy, it cannot at a later stage when a claim is made under the policy say that there was a suppression or non-disclosure of a material fact and seek to repudiate the claim. The insurance company has the right to seek details regarding medical conditions, if any, of the proposer by getting the proposer examined by one of its empaneled doctors. If on the consideration of the medical report, the insurance company is satisfied about the medical condition of the proposer and that there is no risk of pre-existing illness and on such satisfaction it has issued the policy, it cannot thereafter contend that there was a possible pre-existing illness or sickness which has led to the claim being made by the insured, and for that reason repudiate the claim. The insurer must be able to assess the likely risks that may arise from the status of health and existing disease, if any, disclosed by the insured in the proposal form before issuing the insurance policy. Once the policy has been issued, after assessing the medical condition of the insurer cannot repudiate the claim by citing an existing medical condition which was disclosed by the insured in the proposal form, which condition has led to a particular risk in respect of which the claim has been made. In other words, a prudent insurer has to gauge the possible risk that the policy would have to cover and accordingly decide whether to accept the proposal form and issue a policy or decline to do so. And then, my lords, they go on to finally yes. Here in this case, there was a cardiac disease, and the last, second last page, page 33, para 68. Para 68. The terms, the situation is quite identical. Further, what was this to be disclosed in query 8 under the caption medical history was knowledge of any positive existence of any ailment, sickness or injury which may require medical attention while on tour abroad. This was for a foreign travel insurance. This means that any ailment, sickness or injury of which the proposer had positive knowledge of and which may require imminent medical attention while on tour abroad and during the term of the policy had to be disclosed. If the proposer had no knowledge of any ailment that he had, obviously there would be no disclosure of any ailment or sickness which would require medical attention while on tour abroad. In fact, the aforesaid query has also to be considered in context of the further declaration sought by the insurance company to the effect that so-and-so, whether he was traveling against the advice of physician, etc. Para 69. Viewed in the aforesaid perspective, it is held that the respondent insurance company could not have repudiated the policy on the ground that acute myocardial infraction suffered by the appellant on landing at San Francisco was a pre-existing and related complication which was excluded under the policy. The insurer was informed about the pre-existing condition of the appellant, namely diabetes. Here what the insurer said, you said diabetes, this is the condition related to diabetes. And it was for the insurer to gauge a related complication under a policy as a prudent insurer and then issue the policy when satisfied. In the absence of the same, the treatment availed by the appellant for acute myocardial infraction in USA could not have been termed as a direct offshoot of hyperlipidemia and diabetes so as to be labeled as pre-existing, which the appellant suffered from and has not disclosed. And thereafter, my lords, in the last paras, again, they say that this was not something that could be repudiated. So, my lords, my submission is simple. I was never given any unequivocal information that either my symptoms or my condition or my diagnosis was arising out of multiple sclerosis. I had certain conditions of vertigo. I was given those examinations, and there was the only thing where multiple sclerosis was mentioned was in brackets with the question mark, which means that the doctors themselves were unsure. I was never informed. The only time I was diagnosed was in 2020, 3 years later. I made the claim. When I made a claim in 22.
Lord, the appellants herein had availed housing loan from HDFC Bank. But to safeguard the loan amount, the bank insisted for obtaining a policy. Then they approached the second respondent hearing and they obtained the policy. Lord, this is not a mediclaim policy. This is not a mediclaim policy. What Madam read out all these things, this is in respect of mediclaim policy. This is. Please, please. Home loan. Covering the risk of the building as well as the persons who availed loan. Please. Lord, what are the major medical illness that is covered, stated in the wordings of the policy? Lord, in this case, my lord, the hospitalization is from 27/3/2017 to 30th of March 2017. Of 2017. Hospitalization, first hospitalization, my lord. First hospitalization at Bangalore Baptist Hospital. Then, my lord, diagnosis. The diagnosis mentioned in the discharge summary. My lord, page 108, my lord, of the compilation. The name Jaya Matthew, hospital number, age, date of discharge, date of admission, diagnosis, acute vertigo, white matter, disease of CNS. Not CNS means complete nervous system. Chief complaints, Ms. Jaya presented with complaints of giddiness, 1 week, rotatory type, vomiting, history of tinnitus, ear discharge, hearing loss, tremors, LOC. My lord, may kindly see past history. Past history. Next line, my lord. Up past history. History of syncopal attack 7 years back. General physical examination and all. Systematic examination. Respiratory system, okay. Cardiovascular, abdomen. Course in the hospital. Mr. Jaya was admitted with the above complaints. Initial differential considered were vertigo, posterior circulation stroke. She was started on symptomatic treatment with beta hestis. MRI done outside showed T2 hyperintense lesion in the dorso-medial aspect of upper pons. Therefore, they mentioned as multiple sclerosis ? Neurology report was advised ECG, NCV, VEP, 2D echo done was normal. ENT consult was sought and advised conservative management. Her vitals, sugars, urine output were regularly mentioned. She improved with the above care and is being discharged in a state of condition with the following advice. Symptomatically better, 96%. Vertin, Diligin. This is for vertigo. To review neurologically with date was fixed. Now the policy was obtained on 29/4/2017. Immediately after the discharge, after 1 month, they approached our company in the proposal forum. It is at page 129. It is stated. Not walk-in, my lord. In the top, my lord. Home Suraksha plus proposal forum, walk-in. It is written. So they came on their own and submitted the proposal form, have obtained the same from the second respondent, and they have filled the walk-in, my lord. So nobody insisted them. They are the walk-in customers. So bank had insisted, my lord, and therefore they obtained policy from many of the insurance companies. In the name of the nominee mentioned, kindly tick the appropriate condition. My lord, suppression of material fact. Just 1 month ago, for what she was diagnosed, at least she would have mentioned here. Then, my lord, it is the option for the insurer. Question mark. Question mark. Then, my lord, I may be permitted to read the Ombudsman order first. Ombudsman order, who made the order first. Page number 106, my lord. After hearing personally, the insurance ombudsman passed the order. Page 106, my lord. Second paragraph. Medical records of 2012 of Columbia Asia Hospital reveal that she has past history of vertigo since pre-pregnancy. The MRI report of Columbia Asia Hospital dated 27/3/2017 reveals that doctor on the basis of the symptoms experienced by IP suggested that she might be suffering from MS. 2 flare hyperintense ovid lesion was seen in dorsomedial aspect of upper pons. Hypertense T2 lesions are defined as sharply demarcated regions of high signal intensity compared with surrounding brain issue. The report suggested features could be possible of demyelinating etiology like MS and less likely of infective etiology. Thereafter, she was hospitalized at Bangalore Baptist Hospital from 27/3/2017 to 30th of March 2017. The discharge summary of Bangalore Baptist Hospital records the final diagnosis as acute vertigo and white matter disease of CNS. Therefore, my lord, 1 month prior to that, yes, my lord, yes, ma'am. Yes, my lord. My lord, stopping functioning of brain, my lord, CNS, central nervous system. My lord, she was having vertigo, my lord. It is even their argument. Therefore, she was on medication for vertigo, even as per the discharge summary of the 2017 March hospital records. Internet study reveals that white matter disease or leukolysis is a disease that affects the nerves that link various parts of the brain to each other and to the spinal cord. White matter tissue that includes nerve fibers, axons, which connect nerve cells. A fatty tissue called myelin covers the axons. These axons connect the neurons of the brain and spinal cord and signal nerve cells and to communicate with one another. Degeneration of the white matter, specifically the myelin status, can affect a person's mood, locus, muscle strength, vision, and balance. White matter disease may develop with conditions associated with aging, such as stroke, but it can also affect young people due to conditions such as cerebral dystrophy and multiple sclerosis. This is the medical study reveals. The condition that results in damage to the protective coverage, melatonin state that surrounds nerve fibers in the brain, optic nerves and spinal cord is called demyelination. MRI is the imaging modality of choice to assess demyelinating disorders of the brain and the cord, and together with the clinical and laboratory findings can accurately classify them in most cases. Forum notes that IP took the policy immediately after being diagnosed with the above conditions. Perusal of proposal forum reveals that IP was first one, my lord. Second one for which she diagnosed. Policy, my lord. My lord, subsequently she took my lord, subsequently she took treatment for the same ailment, my lord. Yes, my lord. But that is what stated in the discharge summary in at page 156, my lord. Eliminating disease, multiple sclerosis, vitamin D deficiency. 156, my lord. For which she has taken treatment and made the claim. Yes, my lord. 20. Material facts. Please, ma'am. Lord, my submission is. Yes, ma'am. Please, ma'am. And therefore, she took the same treatment as is found in 156, that is Vikram Hospital discharge summary, eliminating disease multiple cirrhosis, vitamin D deficiency, under which she made the claim. Lord, the claim is under this one only for discharge summary, ma'am. For this, the treatment only. Yes, ma'am. Under. No. Milord, therefore, Milord, internet study is made on this and by the Ombudsman. Please, ma'am. Correct, ma'am. Please, ma'am. Milord. 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 Milord, my submission is, Milord, based on the information submitted by the insured persons by mentioning in the proposal forum, we are issuing the policies with utmost good faith. Milord, she took treatment. Her ailment or not, it is not discussed, as my lords told, it is in question mark, because final diagnosis was not taken place while obtaining the policy. At least they could have mentioned, Milord. Then the insurer is at liberty either to issue the policy or to mention any condition forthwith that. Yes. Then I might have given the policy by putting a condition, Milord. Then it comes pre-existing. After 48 months only, this disease will cover under the policy. First 4 years, Milord. 48 months, it will not cover. 48 months. Any pre-existing, it will cover after completion of 48 months from the inception of the policy. Please. Oh, my lord, if something is mentioned in the proposal forum, that pre-disease will risk commence after completion of 48 months. If nothing is mentioned in the proposal forum and they took treatment subsequently also, it is not covered. That is my humble submission. Please, please. If it is mentioned in the proposal form. Please. Please. Non-disclosure of material fact. Please. Lord, I may permit to read only one paragraph. My submission, my lord. This is suppression of material fact. Lord, what for she was diagnosed in the tooth? My lord. Will you say that this is the final diagnosis? Not therefore. No, I mean, no, no. As my lord read over pre-existing, if something is in their mind or into their knowledge, they would have mentioned in the proposal form. In the recent past, I have diagnosed for this and I have taken treatment. My lord, my humble submission, my lord, she was tested in 2007 before obtaining the policy. For the same ailment, she took treatment in the year 2020. My lord, page number 106, last paragraph, my lord. Forum notes that column for MS was left blank even though MRI report of Columbia Asia Hospital suspects signs of MS. Further, neither the pre-existing medical condition of vertigo nor the diagnosis of white matter disease of CNS was disclosed in the others column in the proposal form dated 22/4/2017. A relevant expert from the proposal form is shared below. Next, my lord, by relating my lord, page 106, last paragraph, my lord. The order of the Ombudsman. Forum notes that column for MS was left blank even though MRI report of Columbia Asia Hospital suggested signs of MS, as there was question mark. Further, neither the pre-existing medical condition of vertigo nor the diagnosis of white matter disease of CNS was disclosed in the others column in proposal form dated 22/4/2017. Hypertension, diabetes, multiple sclerosis, my lord, others, my lord. Last one is others, my lord.
That means everything.
Others should have mentioned. Therefore, not based on the even in others also they would have mentioned. Not relying on the decision held by Honorable Supreme Court in Satwat Kumar case, a mediclaim policy is a non-life insurance policy meant to assure the policy. Alas, this is in page 107, my lord. They have extracted the same. In Satwant Kaur Sandhu versus New India Assurance Company on 10/7/2019, the Honorable Supreme Court has held that a mediclaim policy is a non-life insurance policy meant to assure the policyholder in respect of certain expenses pertaining to injury, accidents, or hospitalizations. Nonetheless, it is a contract of insurance falling in the category of contract Uberrimae fidei, meaning a contract of utmost good faith on the part of the assured. Thus, it needs little emphasis not when an information on a specific aspect is asked for or in the proposal forum. An assured is under the solemn obligation to make a true and full disclosure of the information on the subject which is within the knowledge. My lord. Yes. My lord, this is in respect of mediclaim. My lords are true. My lord, then I rely on page 139 as my lords read out twice. Pre-exist 139, my lord. Pre-existing means serial number 38. Pre-existing means any condition, ailment or injury or related conditions for which you had signs or symptoms and or were diagnosed and or were received medical advice or treatment within 48 months prior to your first policy with us. This is, my lord, concealment of material fact. Cold and fever. True. After tests are conducted, no, my lord, the wordings are very clear, my lord. Anything in their knowledge that has to be disclosed. Pre-exist. ಹೇಳಿದರು. ಅದಕ್ಕೆ my submission is in 2007. Yes, bacteria. Therefore, my submission is in 2017, before obtaining the policy, 1 month earlier, what she was diagnosed is the reason for the final discharge in the 2020. That is the continuation. Multiple cirrhosis. It was not that it was doubted on that time, and subsequently they confirmed in 2020 in the discharge summary. Please.
After 1 month, it's serious. People will not know what is coming after 1 year or 1 month. He said today I have 4 filings, only 4. So we not mentioned the heading others. Actually, contemplating there any serious issue with you, which you need to disclose, you will have a hearing on the policy.
Lord, please, in this case, my lord, they would have mentioned, because she is not a layman, she would have disclosed. This is the Lord, I may be permitted to read the finding of the learned single judge, my lord, that is left out.
Claim, my lords. Claim was for 28 lakhs, my lords. No, no, no. It is from after she went in 2020. Not from. I'll just this slide. Yes. Yes. My lords, this 28 lakhs claim is made as per the policy. Under the policy, if any of the critical illness claim is made, then you get, there are two, the entire law, yeah, they get half of it. In fact, presently, since 2020, since she's been diagnosed, her medical treatment comes up to almost 1 lakh a month. Or 1.5 lakhs every 50 days. That is her treatment. So she now incurs 1 lakh a month, almost 1 lakh a month every month. No, this is the terms of the policy. The policy, the loan amount was for 56 lakhs for both of them. And if the claim is to be made for any illness for the insurance, then each one can get half of it. So her share, the max she can get is 28. She made the, no, it's not for a period. That is the amount under this policy. Yes, it is her actual expenses are would have far exceeded because it's been about 4 years. So her actual expense under the illness has far exceeded, but this is the cap. She can't claim more than this. One time, she can't claim more than this under this policy. Though her expenses are more, because 24 months, I mean, more than 48 months have lapsed. I'll just see there's a claim form. My lords, the claim form is at page 163. Yes. It's a form, my lords. It's at page 163. The relevant typed portion is at page 165. The typed is at page 165 is the claim form, where she writes the loan account number, section under which the claim is being made is major medical illness, multiple sclerosis, and documents attached. She attaches all the documents. So the claim is just a one-time claim. That's all they can do under this, as per this policy. It's a standard claim form. There is no, it cannot be. In fact, her expenses are far more. Her expenses are for life. Yes, it's not against the expenses. Yes. My lords, I can only explain it if we, and my submission is the pre-existing has to be read with two things, my lords. The form, which is at page 125. Form is at page 125, which I left blank. Here, there are specific illnesses mentioned. that please denote whether you have any of these specific things where multiple sclerosis is mentioned. My learned friend says others I could have put. It's, yes. It's not very clear. It says kindly tick the act. Yes. For insurance has been diagnosed. Yes. Now, so I would first say that kindly tick if you have been diagnosed or suffering from any symptoms for these conditions. Now, one thing, so if I have any symptoms or diagnosis of MS, I have to tick it. Over here, I would just like to pause to say my learned friend said others. Now, I can't be expected to say all other conditions. Then yes, then MS, that is multiple sclerosis, any condition or symptoms, which is at page 144, the policy says very specifically that the diagnosis, including symptoms, the diagnosis which says that investigation with the typical MRI and CSE findings, which unequivocally say that the diagnosis is multiple sclerosis. There must be current clinical impairment of motor or sensory function. My lords, CNS white matter, my lords, is all based on medical and in fact, not even medical, internet study. Ultimately, the symptom of multiple sclerosis is degenerative motor and sensory function. That is the illness. And that would be the symptom, not giddiness or nausea or vertigo. I can get vertigo or giddiness even if I have not had a meal. But that is not the symptom. The symptom is loss of motor or sensory function, which must have persisted for a continuous period of 6 months, well-documented clinical history of remissions and other causes of neurological damage. So I should have some symptoms of that. Yes. At that time, like my lord said, at that time they diagnosed it as vertigo. The others. Yes. Now, if I would have mentioned, supposing my lords asked me the question, then it is up to the insurer to ask more if they want. In fact, I just took instructions, though it's not on record and I cannot prove it. And I'm not sure whether my friend has instructions. But when even at that time, my friend says, you could have mentioned. In fact, even those 3 reports which were done before, I had shown it to them. I said, I don't know what this is, but I have shown it and they took photos. Then they also did not pursue. I also did not pursue because in my, and these 3 medical reports, when I was signing the documents, yes. In fact, when my lords asked me the question, I don't have a record of having submitted it, but I physically showed it. They took photos on their phone. But it was just what they took. Nobody investigated. And it was never. I have not mentioned it. But I have not mentioned it. But since my lords asked, I asked the client, had you given it earlier or did you give it first? She said, we gave physical records on record when we made the claim. But in fact, even when we were signing it, we clearly said that we don't have any condition. But there is no record of it. In fact, we asked, since my lords asked, we said, let me clarify. They have also not recorded. They just, these insurance persons are just individuals. They came and took it. Now, my lords, I cannot be under an obligation or even awareness that I have to mention vertigo in others. They have not. In fact, they were free to ask for any medical diagnosis if they want. In fact, that's what, if they want, they can do it. They could have done it.
Lord. My lord, I may be permitted to read.
On the
only.
pre-existing. My lords, my only submission on pre-existing is, pre-existing, though it may say any condition which ailment, injury or related conditions for which you had signs or symptoms or diagnosed or received medical advice or treatment. A reading of this would mean I should have some signs or symptoms or received medical advice or treatment with regard to a condition or an illness. If the illness is multiple sclerosis, which is one of those 6 illnesses in this case, my symptoms or condition I have gone to 3 persons should be linked quite unequivocally that it is multiple sclerosis. I have been told it's vertigo. I have been told it is white matter CNS. My lords, my friend said I'm not a lay person. I am a lay person. I'm not I may be an educated working person, but I'm not a medical expert. My lords, in fact, I have produced even a multiple sclerosis review with my document. White matter CNS may be one of the conditions. And in fact, the central nervous system, my lords, there may be many other situations or illnesses which may have degenerative conditions. White matter CNS may be one of it. And I ask myself the question, if there is any diagnosis of white matter CNS, what prevents the doctor from saying multiple sclerosis? Just say it. I'm not holding a gun to the doctor's head. Grateful, my lords.
My lord, I may be permitted to read one paragraph, my lord, from the extract of the judgment made by the learned single judgment. My lord, page 59, my lord. The insurance ombudsman, on looking at the material records of the first petitioner, right from 2012 comes to conclude that records would reveal history of vertigo since pre-pregnancy, and the suggestion at Columbia Asia Hospital or Baptist Hospital was that she might be suffering from MS, and the discharge summary of the Baptist Hospital was white matter disease of the CNS. The research of the study is made and the claim is rejected. Lord, next one is, my lord, I rely on a English law on this point, my lord, at page 63. Paragraph number 33. The learned counsel appearing on behalf of the insurer submitted that where a warranty has been furnished by the proposer in terms of a declaration in the proposal form, the requirement of the information being material should not be insisted upon, and the insurer would be at liberty to avoid its liability, irrespective of whether the information which is sought is material or otherwise. For the purposes of the present case, it is sufficient for this court to hold that the present facts that the information which was sought by the insurer was indeed material to its decision as to whether or not to undertake a risk. The proposer was aware of the fact while making a declaration that if any statements were untrue or inaccurate, or if any matter material to the proposal was not disclosed, the insurer may cancel the contract and forfeit the premium. McGilvery on Insurance Law, 12th edition, Sweet and Maxwell, 2012, page 257 for cases relied upon, formulates the principles thus. In more recent cases, it has been held that all important element in such a declaration is the phrase which makes the declaration the basis of contract. These words alone show that proposer is warranting the truth of his statements, so that in the event of breach of this warranty, the insurer can repudiate the liability on the policy irrespective of the issues of materiality. My lord, by considering the judgments of the Honorable Supreme Court, my lord, the writ petition was dismissed, my lord. I am relying on the decisions, my lord. Compilation was made. Compilation was made. Two full bench decisions of Honorable Supreme Court, my lord. My Lord, first one is branch manager Bajaj Allianz Life Insurance and Dalbir Kaur, paragraph 9, 10. Lord, 9, my lord. A contract of insurance is one of the utmost good faith. A proposer who seeks to obtain a policy of life insurance is duty bound to disclose all material facts being upon the same as to whether the insurer would consider it appropriate to assume the risk which is proposed. It is with this principle in view of the proposal form requires a specific disclosure of pre-existing ailments so as to enable the insurer to arrive at a considered decision based on the actuarial risk. In the present case, as we have indicated, the proposer failed to disclose the vomiting of blood which had taken place barely a month prior to the issuance of policy of insurance and of hospitalization, which had been occasioned as a consequence. The investigation by the insurer indicated that the assured was suffering from pre-existing ailment consequent upon alcohol abuse and that the facts which were in the knowledge of the proposer had not been disclosed. This brings the ground for repudiation squarely within the principles which have been formulated by this court in the decisions to which the reference is made earlier in Life Insurance Corporation of versus Asha Goyal. This court held. Lord, next, my lord. Second one, my lord, Oriental Insurance Company versus Mahendra Constructions. Paragraph 11 and 12. This is also full bench decision. Paragraph number 11 and 12. Paragraph number 11 and 12. My lord, emphasis supplied. Next, my lord. Page 4. It was further held that there is a clear presumption that any information sought in the proposal form is a material fact. The upshot of the entire discussion is that in a contract of insurance, any fact which would influence the mind of a prudent insurer in deciding whether to accept or not to accept the risk is a material fact. If the proposer has knowledge of such, he is obliged to disclose it particularly while answering questions in the proposal forum. Needless to emphasize that any inaccurate answer will entitle the insurer to repudiate his liability because there is a clear presumption that any information sought for in the proposal forum is material for the purpose of entering into a contract of insurance. Information regarding insurance claims lodged by the respondent for his excavator in the preceding 3 years was a material fact. The burden of establishing that the insured made a false representation and suppressed material facts lies on the insurer. The insurer has placed on the record the best possible evidence in support of the plea that there was a misrepresentation and suppression of material facts. The mere disclosure of previous insurance policy did not discharge the obligation which was cast on the respondent as the proposer to make a full, true and complete disclosure of the claims which were lodged under the previous policy in the preceding 3 years. The proposal form contained a specific question regarding claims lodged in the preceding 3 years. The respondent was under the bounden duty to disclose that the excavator was previously insured with another insurer and that the claim for damage to excavator on 12 April 2004 had been settled. It was only in the affidavit of evidence dated 6 January 2017 that the respondent disclosed that New India Assurance Company Limited had paid an amount of 36.66 lakhs by check on 23/9/2000. This material fact was suppressed from the proposal forum. Lord, final paragraph numbers 16. We accordingly allow the appeal and set aside the impugned judgment and order of the National Commission dated 19 September 2018. The complaint filed by the respondent shall stand dismissed. My lord, third one, my lord, Reliance Industries versus Rekha Ben Naresh Bhai Rathod. This is in respect of same lord contract of insurance proposal. This, my lord, I conclude, my lord. Yes, my lord. 18, 19, 21, and 23 to 29.
Yes. I just wanted to, just 2 minutes, my lords. The first Bajaj Alliance judgment is actually covered in the 22 judgment. In fact, has been considered in the latest decision. Yes, yes. So that has already been covered, and thereafter this, the finding is given that these deductions what my friend said, that CNS white matter disease, all of that deduction is made by the Ombudsman after internet study and all that research. My lords, is a person who is filling up a form supposed to be aware that all these connections are made? It is only when I get a final diagnosis. Great.
Will not appear for respondent number 1, my lord. Will not appear for respondent number 1, my lord. Please me.
Letter about that.
Please me. Virat.
Great.
Query for the appellants, Your Lordship. I pray for 2 weeks' time. There's one clarification which has the defendants have to be given in terms of the compromise petition. So we need 2 weeks' time, Your Lordship. No specific date may be given. If the matter is settled, we'll report it in the next week itself by moving in. Your Lordship. Yes, sir. To report separately. Obliged.
What I appeal for the appellant. If it's not inconveniencing your lordship, kindly accommodate me by 1 week, my lord, because I banged my teeth in the morning yesterday. I banged my teeth while brushing, my lord, yesterday, and little bit of a problem. I can't speak properly, my lord. Week after next will be coming because communication. Much obliged. My lord? Much obliged. Sorry, my lord.
Not for the appellant, my lord. Yes, my lord. I think there's some. Yes, I think that's it. Grateful.
Contesting respondent not appear to.
Appear for respondent, my lord. The week after next month. Great. But the date may be fixed, my lord. But the date may be fixed. That the date may be fixed, my lord. Great.
For the respondent, my lord, recollect my lord,
For the-
heard at some length on RERA. On the RERA payment issue. Yes, yes,
Pre-deposit.
the pre-deposit issue.
Your Lordship, as we had advanced arguments on the previous date of hearing, we wish to draw a distinction between cases where a refund is ordered by the authority and where only delay interest is ordered, Your Lordship. Your Lordship, I'd like to place on record a few judgments of a coordinate bench of this honorable court. Yes. Your Lordship, in the instant case, in the order which I've furnished before your Lordships, the order which I furnished before your Lordships, the question of law was very similar, was the same as the one in the instant case. The Honorable Court, after perusing the arguments, has held that in para number 12, your Lordship, it is clear from a plain reading of the judgment in the case of Newtek, that an appeal can be preferred against the order of the adjudicating officer awarding delay compensation, and the appellate tribunal is required to consider the appeal on merits if the appellate deposits 30% or such other percentage of the award as may be awarded by the appellate tribunal. Your Lordship, Your Lordship, in this. No, Your Lordship. In this case also, the appellate tribunal had directed that 100% be deposited. The facts in the earlier paragraphs it's narrated, Your Lordship. I will take you to that paragraph. Yes, Your Lordship. Your Lordship, it will, Your Lordship. Just allow me one moment, Your Lordship.
In fact, the issue, my lords, was on 43.5 proviso of the RERA Act. Just to refresh my lords' minds, 43.5 proviso. The proviso. Provided that where a promoter files an appeal with the appellate tribunal it shall not be entertained without the promoter first having deposited with the appellate tribunal at least 30% of the penalty or such higher percentage as may be determined by the appellate tribunal, comma, or the total amount to be paid to the allottee, including interest and compensation imposed on him, if any, or with both as the case may be before the appeal is heard. In our case, the situation is it's not a penalty. Penalty is where there is a violation and minimum 30% or anything. What has been granted to me is the delay compensation and interest. In such a case, the total amount has to be paid. And the judgments that we gave say that in the second situation, where a compensation here, my lords, they didn't complete the flat within the time given under the agreement. And there's been a delay of about 3 to 4. Therefore, a delay compensation has been given to me. It's not a penalty. And so the judgments under New Tech and others say that there is no discretion. You have to pay the full 100% before an appeal is even heard. They didn't give the 100% before the RERA appellate tribunal. Therefore, on this, without going into the merits, the appellate tribunal said you've paid only 30%. This is not a penalty. This you have to pay the full delay compensation. You pay it. They didn't pay it. New Tech deals with it in a limited way, and then I gave a Allahabad High Court decision and our own High Court decision. My learned friend has given one more decision. My submission would be that that decision is with great respect per incurium. It is not correct, and that is a stray order that unfortunately maybe without proper instructions to the... So my compilation was given, if my lords can see. In fact, New Tech also refers to that. The Allahabad High Court and our, yes, if my compilation can be taken, my lords. The total amount that is at page 46, para 121 of New Tech, my lords. Page 46 of my compilation. Para 121 at the bottom of the page. May I read out, my lords? It may straight away starts with that line. I'm not sure if my lords have my compilation. Yes, page 46, para 121. It may straight away be noticed that section 43(5) of the Act envisages the filing of an appeal before the appellate tribunal against the order of an authority or the adjudicating officer by any person aggrieved. And where the promoter intends to appeal against an order of the authority or adjudicating officer against imposition of penalty, the promoter has to deposit at least 30% of the penalty amount or such higher amount as may be directed by the appellate tribunal. Then, my lords, where the appeal is against any other order which involves the return of the amount to the allottee, the promoter is under an obligation to deposit with the appellate tribunal the total amount to be paid to the allottee, which includes... Sorry. Yes. No, refund.
Exactly, Your Lordship.
No, 1 minute, sir. Refund, and also it says, which includes interest and compensation imposed on him, if any, or with both, as the case may be. Yeah. Yes. No, in our case, it's not a refund. Yes. Normally,
Lordship,
refund is there, then there is interest.
Interest is also
Then interest. There may not be compensation. Yes. Where the, yes, return of the amount to the allottee, the promoter, yes.
We are granting under this, we call it must be, call it that is this one. So it must be recalled. Maybe suppose he doesn't succeed, the promoter doesn't succeed. The amount can be given from the tribunal.
The
case, there is a compulsion. That compensation, we to the extent whatever Can we say compensation, 100% of the compensation awarded must be deposited?
That's the. No, my submission is, my lords, if we read, though New Tech was with the entire challenge to the Act, to the RERA Act. So therefore, New Tech didn't go into individual issues. It delineated in para 121. Thereafter, my lords may see, a more clarification is given in the Allahabad High Court and our High Court. Kindly see at page 54. At page 54 is an Allahabad High Court decision. And the relevant portion, my lords, is at, yes. Yes. So where interest is imposed, then full interest. Where compensation is imposed, then both, if in case both are imposed. So in those cases, whether it is refund of amount or interest or compensation, entire 100% has to be deposited before appeal is heard. Where it is a penalty has been put, where penalty has a separate section under the RERA Act. Where a penalty has been put and you're challenging that penalty order, there you pay 30% or any additional amount. Yes. Yes, yes.
Your Lordship, if I may make a small submission, Your Lordship, para number 126 and 136 of the New Tech judgment further clarify this position which we are on, Your Lordship, because question number 4, which is the issue number 4, which is which pertains this discussion, is whether the condition of pre-deposit under proviso to section 43(5) of the Act for entertaining substantive right of appeal is sustainable in law. Your Lordship, para 136 and 137 specifically say that 100% deposit is mandatory only in cases of refund, as your Lordship also just raised that doubt. It is only when money is to be returned back to the allottee and not in cases of delay interest. Your Lordship, I may be permitted to read para 126, Your Lordships, if Your Lordships have it in the compilation. 30%, Your Lordships. Your Lordship, para 126 reads, it may further be noticed that under the present real estate sector, which is now being regulated under the provisions of the Act 2016, the complaint for refund of the amount of payment which the allottee customer has deposited with the promoter, and at a later stage when the promoter is unable to hand over possession in breach of the conditions of the agreement between the parties, are being instituted at the instance of the consumer allottee, demanding for refund of the amount deposited by them, and after the scrutiny of facts being made so. The legislature in its wisdom has intended to ensure that the money which has been computed by the authority at least must be safeguarded. So, Your Lordship, we find that both para 126 and 136 specifically only delve into refund cases where the entire money has to be safeguarded, as this judgment has pointed out. Even in para 136, Your Lordship, in our considered view, the obligation cast upon the promoter of pre-deposit under section 43(5) of the Act, being a class in itself, and the promoters who are in receipt of money which is being claimed by the home buyers allottees for refund and determined in the first place by the competent authority. If legislature in its wisdom intended to ensure that the money once determined by the authority be saved, if appeal is to be preferred at the instance of the promoter after due compliance of pre-deposit, as envisaged under 43(5) of the Act, in no circumstance can it be said to be onerous as prayed for in violations of Article 14 or 19(1)(g) of the Constitution of India. Throughout question number 4, question number 4 of the New Tech judgment, which talks about the requirement of 100% statutory deposit, nowhere does it go beyond the scope of 100% full refund. In fact, the words used even in the Bare Act are return and refund. It never goes into delay interest, delay period interest at all, Your Lordships. Your Lordships, further, 30%, your lordship. Exact amount I can tell you, your lordships. Compensation, delay compensation.
Delay
Your lordship,
compensation.
there's one more issue.
My lords, my lords, the compensation awarded is, my lords, the RERA order, if my lords may see, it is at page 58. Page 58, my lords may see, the final order states that the developer shall give compensation as delay compensation from July 2018 to the complainant by obtaining OC, including all amenities for giving possession, etc., and an additional 2% interest other than the interest fixed on the housing loan by SBI. So, my lords, that is around 8%. So, in fact, I had given a list of dates to my lords, wherein the current calculation of compensation, according to us, my lords, they handed over the flats to us in August 23. And from July 2018 to August 23, the delay compensation, according to us, is about 26.5 lakhs on each flat. There are 2 flats, so it would be around 53 lakhs. We have made a calculation. So they have only paid about 4 lakhs they have paid. This is the delay compensation.
Your lordship, I'll.
They have deposited around 4 lakhs over there. And thereafter, they were asked to deposit some amount here. And they deposited about 8 lakhs here.
Yeah, in this court, is a lordship.
But the entire delay compensation has not been deposited. Where refund is sought. That is only in limited cases where the flat is nowhere near handing over. And then I say the money is to be given back. No, my lords, in my case, my submission is that, my lords, in fact, in some of the other decisions, in fact, even the RERA Appellate Tribunal has made 3 kinds of situations. One is there's a penalty. Second, the flat is not completed, the amount is refunded. So along with refund, some interest may be given. Third is where the flat is completed, but after a great delay. In those cases, the delay compensation is given. Now, in the proviso, the act is very clear, which says that it shall not be entertained an appeal without the promoter first having deposited the total amount to be paid to the allottee, including interest and compensation imposed on him, if any, or with both, as the case may be, before the appeal is heard. Now, New Tech elaborates it briefly. Thereafter, because the issue was not this in New Tech, the issue was the entire challenge to the act. In fact, New Tech goes on to say that this amount is directed because it should be saved. Otherwise, he will not even pay me this 52 lakhs. No other stipulation. And Allahabad High Court and our own High Court go on to say that where delay is there, you have to pay the full amount before your appeal is heard. My learned friend may have given a judgment which, with great respect, sometimes these decisions are not explained to the.
Yes, Your Lordship.
Which is per incurium is my humble submission, because we have a coordinate decision of our court.
Your Lordship, there is no direct, yes.
So far as the penalty is concerned, that's clear. There is no issue on that. Or any other. So far as the complete refund is concerned, possibly you would also not address it. Refund, it has to be
Understand.
when it comes to the other section.
The proviso.
Monies, refund, what has been paid by the authority, please, plus, and compensation. That need to be paid in full.
In fact, the proviso
Your
does not
Lordship,
even
I have-
say refund.
Your Lordship,
It
I have
only
just
says
one
the
small
amount.
submission. I have just one small submission, Your Lordship.
Maybe.
Looking at section 43, subclause, subsection 5 proviso, Your Lordship, it talks about 30% of the interest of the penalty or total amount to be paid. Your Lordship, if interest was also meant to be included as a part of this sex proviso, you would have said or interest, not including interest. Your Lordship, I would beg to differ on that, Your Lordship, because this language of the act, I mean of the proviso prior to interest, including interest, says at least 30% of the penalty or the total amount to be paid. If in delay interest was also meant to be included by the legislature, it would have said or interest or delay period interest or just interest. When it says or the total amount to be paid to the lottery, including interest and compensation, it refers to the interest and compensation that is on the total refund amount, Your Lordship. The use of the word or in previous places and including no or in this part clearly indicates that the legislator never intended to make interest a part, never intended this proviso to be applicable to delay period interest. To delay period interest, Your Lordship. Delay interest, delay period interest, delayed interest. Lordship, yes. Your Lordship, there's one more issue that yes, Your Lordship. Second one. Promoter. Yes, Your Lordship.
Total amount to be paid to the lottery, including interest and compensation imposed on him, if any, or before, as the case may be, before the secretaries.
In some cases, it can be only interest. In some cases, it may be interest and compensation. So whatever is imposed, either one or both, the total amount has to be paid. Yes. 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 Then only the amount. Then only the amount to be given to him. Yes. Ultimately, apart from penalty, what in the other cases after or, whatever amount is to be imposed, whether it is the principal amount, interest, compensation, entire amount has to be deposited.
Your Lordship, if we can also refer to section 18 of the Act, Your Lordship, if I may kindly take you through it.
Make one. Field number 26. my lord. Afternoon, my lord, I have not ordered matter will be called any next week, my lord, 26, my lord, 26.
My lord,
I appear as a respondent in that case.
my lord, in this
No
matter,
objection for some accommodation. I have no objection if my learned friend wants accommodation, I am ready.
one submission, my lord, in this matter, the connected, but connected is not a connected matter. It is entirely different village. My Bangalore district acquisition is the first matter. The second matter, my matter, is Udupi acquisition. It's
That may
entirely
be
different matter.
dealing.
It will deal include.
That may be dealing. ಅದು ಹುಡುಕಿದೆ.
26.1.
My learned friend is appearing, I am not in
I
that.
am appearing for the 26.1. Lord, the matter is entirely different. The first matter, 26.
Continue it.
There's no such order, but I don't know how it got connected. Lord, it could be Lord dealing. Request. Lord, the appellants are same, but my lord, the areas are different, my lord. What? Please, my lord, please. Please. Sure. Please, please. Lord, entry model may kindly be extended in Malad plus. 606 of 21. Fourteen. Yes. Lord, entry model may kindly be. The first matter, 606 of 21. Pleasure.
Serial number 22.
Pardon me, my lords, I lost the chance of mentioning a matter in the early hours of the day. The reason is, this is a appeal admitted about 8 years ago, list between the husband and the wife. And trial court, in 2018, it is in process. Why do I require for an urgent listing of the case? Yeah, it is. Because I am compelled to mention it today at 2:30 because of the considering the grave situation of my client. He's on a pacemaker for the last 10 years. And considering the advance in life, day after day is getting old as we are. And problem is he wants the matter to be settled. Of course, he has to obtain a decree for divorce against his wife. And the whose property is concerned, trial court rightly granted a decree. You take the ground floor and let my client take the first floor. Yet, dispute is before the court. It's very unfortunate irony. It's an irony. Can I mention it, my lords, on Friday? I believe it's going on in the neighboring court. Yeah. So, put on hold. Very well. I will take a chance on Monday. A lot when I mention it on Monday, kindly be kind enough to see that it is listed on Tuesday or Wednesday. If the way is cleared, if the deck is cleared, can it be listed to next day itself so that oblige? Oh, I understand. Those mathematics will have to be also gone into by us. Oblige.
For the appellant, your lordship, pray for one opportunity. Your lordship would like to place a few judgments on record. We'd like one opportunity. In total, 4 lakhs approximate figure before the KREIT. 8 lakhs here. Your lordship, that calculation we have not done, your lordship. Your lordship. Yes, your lordship.
Your Lordship, Miss Kothari is on legs. She had a chamber matter at 2 p.m. that's going on a little longer, but she's just going to be able to make it.
Your lordship. Your lordship, as per our
Lordship, if I can request for the matter to be taken up tomorrow, the arguments are almost complete. And close the matter. Grateful.
Yes.
Senior counsel is on legs in court of senior counsel. University I have read it. University has instructed to us.
These are not worried.
Please. No. Lord, sir, since senior counsel is appearing, I am not prepared very well.
I am for the respondent.
Great. Lords, University is in appeal. My lords, I take my lords to the state of the operative portion of the impugned order passed. Great. Correct. Correct. Yes. Correct. Correct. My lords, for that reason, I'll answer my lord's query. 143 maybe no. Yes. Quashing the ordinance on eligibility criteria for becoming UG PG examiner. Wide notification dated 7/1/2019. Insofar as postgraduate medical courses are concerned. A university itself has admitted that yes, our ordinance is bad, which is contrary to the Parent Act, that is MCA regulation. So if Learner Singh has quashed this ordinance, we have no difficulty. That is 11.1. Yes, yes. We agree. Our ordinance is contrary to the MCA regulations. Yes. No, my lords, all that we have said is that, yeah, as per the said ordinance, my lords, there is a certain criteria fixed who are the qualified examiner to evaluate the papers. Though ordinance says that it is not as per the MCI guidelines, but we have appointed the examiner as per the MCI guidelines itself. So to put it in other words, yes. 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 Yes, yes, yes. Yes. Yes, just place it on record. My lords, it has been called out there. My lords, in the impugned judgment itself, it has been called out. I draw my lord's attention to page number 43. I'm sorry, my notes. The ordinance dated, kindly be seen, 2.10, paragraph, page 45. My lords, my lords. The respondent university has notified the ordinance of eligibility criteria for becoming undergraduate / postgraduate examiner wide notification dated 7/1/2019, exercising the power I'm sorry. If your lordship. Yes. That's what I pointed out the regulations.
It's, I don't know whether lordships have my brief synopsis of arguments.
Last time, copy. Oh, well, let's just supply it. If it is not found, I just.
You took, see?
Yes.
Yeah.
I agree with it.
Okay. It's petitioners before the learned single judge, where the students who had appeared for examination of postgraduate degree course in the month of November 2019. After having appeared, they failed and they questioned the correctness of the ordinance under which they said their papers were evaluated. Then, my lords, the main ground on which they questioned the evaluation process, which was reflected in the ordinance, was that it was not in tune with the regulations made by the Medical Council, which is the apex body. But insofar as university is concerned, before the learned single judge, it did concede that there was some variance between the MCI regulations and the university regulations. The variance was to the extent of the university notifying the eligibility for valuators, equating, my lords, the same year of experience for the internal examiners and external examiners. It did concede, but brought before the learned single judge that though the ordinance was in variance, in practice, the university had followed the MCI regulations and there is no prejudice whatsoever caused to the students. The university, in fact, offered to place it before the learned single judge, the entirety of the evaluators' qualification, etc., which would show that they had much more than what is prescribed under the MCI regulations. The learned single judge, however, said, I will not take it now because you need to disclose who had evaluated, share that information with the candidates. But there's a judgment of the Supreme Court which says in the matter of evaluation, it is not to be disclosed because that is capable of being misused by succeeding student community, or it may have its own effect. So there's a direct judgment which we cited. Since he said you have not shared with them, I'm not going to look into the details of the evaluators who had evaluated these papers. And he held that since the ordinance is in variance with the MCI ordinance, he proceeded to strike it down. During the pendency of the matter before the learned single judge, the university, having realized that it was not in accordance with the MCI regulations, itself had passed another ordinance and tried to place it before the learned single judge. He says he won't take that also, and he quashes that subsequent ordinance also by way of an order made by the learned single judge. It was, no, during the pendency, we brought to the notice of the learned single judge that we owned our mistake, that there was variance, and said that has not made any difference insofar as, yes. Yes. The learned single judge ultimately records a finding that there is no need for an ordinance of this nature. We are regulated by the MCI. Yes, therefore, there was. Yes, no, that is ultimately what has happened. So we were aggrieved by the order of the learned single judge, who not only set aside the ordinance, but also directed the university to re-evaluate the answer script by one other set of evaluators, not seeking to look into the explanation by the university that it was in fact evaluated by competent evaluators. Now we filed an appeal against that order. Your Lordship may kindly have a look at the order of this honorable court by the division bench, which noticed. I'm sorry. Yes, yes. Let's see, order is at page 21. If your Lordship permits me, I have analyzed the judgment, Lords, by my note. So it would be easier for me, Lords, unless there is a dispute about what I have noted. Yes. Let's at page 2 of my submission. Learned single judge, however, on hearing by the judgment dated 8/12, has allowed the writ petition holding that the ordinance providing for appointment of PG examiners is contrary to MCI norms and therefore requires to be quashed, thus quashing both the impugned notifications dated 7/1 and 29/3, as well as the notification dated 29/6/2020, which was promulgated during the pendency of the writ petition, replacing the impugned notification. The learned single judge has refused to look into the sealed cover containing the names and qualifications of examiners who had conducted the evaluation of answer scripts of the petitioners, stating, recording that same had to be disclosed to the petitioners as well. The learned single judge, while allowing the writ petitions and granting the relief to the petitioners, has not taken note into consideration of the fact that the MCI regulations provide for appointment of PG teachers, prescribing the basic qualification which provided that the teacher shall hold a PG degree in the concerned subject and who have the minimum teaching experience as provided therein are to be appointed as PG examiners. As can be noticed, para 2 of the judgment records the contention of the petitioners, among others, by impugned notification of university has lowered the standards, being in clear violation of MCI. I'm trying to skip these as much because I've already narrated, my lords, what were the issue. In order to avoid, my lords, going through the entire of the judgment, which is fairly a big one, I've analyzed, my lords, the gist of the judgment. Para 2.10 notices impugned notification, recording it as being contended lesser than prescribed by MCI, impinging on the rights of the petitioners, also recording the submission. Per para 2.13, university has not differentiated the requisite qualification for internal and external examiners, being in variance with MCI regulations. Para 3.1 to 3.6 notices submissions of the counsel for the petitioners, reiterating the pleadings. 3.8 points out to notification of 29/6/2020 issued during the pendency of the writ petition, university amending the eligibility criteria for examiners, extracts in para 3.10 amended in tune with MCI regulations prescription. It is contended the notification has left the choice of evaluator to chief coordinator and custodian, and university itself has not appointed the process, losing its sanctity. As noticed in para 3.16 and 3.17, petitioners counsel had relied upon two decisions, Nilesh Mehta and Harita, that had dealt with superior legislation regulation by MCI overriding the ordinance, subordinate legislation by the university. There is no dispute on the proposition made therein, but has no relevancy to the issue on hand.
Para 4.1 to 4.26 notices the stand of the university. Para 6 sets out the points for determination. May I draw your lord's attention to page 96, my lords, at this stage, which are the points for determination. Page 96, my lords. The two major issues, my lords, which set out were whether university can formulate the qualification of exams being both internal and external, lesser than the qualification prescribed, whether the ordinance on eligibility criteria for becoming UG, PG examiners dated so and so is in accordance with MCI guidelines, whether the ordinance governing postgraduate including PG diploma and super specialty answer scripts evaluation is in accordance with the MCI guidelines insofar as it relates to postgraduate medical course. What would be the consequence of the eligibility criteria for becoming an examiner and guidelines prescribing for postgraduate diploma answer scripts evaluation booklets being contrary to the MCI guidelines? What order? This has been answered in para 7. Para 7.6 may kindly be seen. Incidentally, I may point out, it was considered before the learned single judge that it is in variance and it is not in exact words as the MCI. After noticing the submission by the university, which was set out in para 7.3, it's maybe of some relevance to read 7.3 as well. I will just read it. The other legal contention raised by the petitioners is that the appointment of examiners is contrary to MCI regulation. It is a fact that the impugned notification dated 7 was issued by the university, but the same was not acted upon as the same goes contrary to MCI regulations and thus no examiners are being appointed contrary to MCI norms. This was the stand of the university. In fact, the process of amendment to change the ordinance is already in the pipeline. All the answer scripts of the petitioners were evaluated by PG teachers who are qualified to be the examiners as per MCI norms. This response will make available the entire records revealing the names, qualification, and teaching experience of the teachers who evaluated the answer scripts of each petitioners to this honorable court and a seal cover for the perusal of this honorable court at the time of hearing of these petitions to justify the fact that the evaluation of the answer scripts of the petitioners is done by the teachers who qualify as PG teachers as per MCI norms. Hence, the petitioner's grievance in this regard is only imaginary and liable to be rejected. This was the stand of the university. Then it notices that this has been considered by the university and para 7.6. In the present case, qualification of the examiners being fixed by the MCI, it is but required that the college and university, as the case may be, in respect of internal as well as external examiners be followed so that the standards by the MCI is achieved. I answer point number 1 by holding that the university cannot formulate qualifications of examiners being both internal and external lesser than the qualification prescribed by the MCI. Then point number 2 was, lords, whether it is in accordance with same. It's the repetition of that. It ought not to have, especially when it was pointed out that it has not caused any prejudice whatsoever. Lords, redoing it would only be doing it more for academic purpose because the fact remains that it was already done by competent authorities. But it was apparently an oversight in framing the ordinance by the university, by the authorities of the university, syndicate and academic body. But then once it was realized, they tried to correct it. Now the question for your lordship's consideration is whether such a variance, when university has come forward to show that in accordance with MCI regulations, ignoring this ordinance, we are in compliance with the requirement of law. MCI regulation says you should have a minimum of 3 years experience with the qualification of a professor. It's not in dispute. On the contrary, my lords, in fact, if your lords are to see the division bench order, which I was attempting to point out to your lordship's consideration, by an order dated 3/4/2012, have you attached it to the note? Yes, my lords, before your lordships, my lords, when the matter came up for admission before this honorable court, give the copies, no? Good. Let's see if there is one more copy. Lords have, my lords. Says this court on 15/4, my lord has that, my lord. 23/4/2021. This court on 15/4/2021 has directed the appellant university to submit an affidavit stating as to whether the Medical Council of India regulations in respect of PG examination have been followed or not. The university was also directed to inform this court as to whether it has followed its ordinance, which was contrary to Medical Council of India regulations guidelines. An affidavit has been filed by Dr. Ramakrishna Reddy, Registrar of University, stating categorically that despite the fact that the ordinance dated 7/1 has been promulgated by the university in respect of eligibility criteria of PG examiners, the university has adopted the MCI regulation guidelines only, meaning thereby that for external examiners, the requisite qualification is 3 years experience as PG teacher, and for external examiners, an experience of 6 years as PG teachers. The university has appointed all examiners having aforesaid experience only. A list of examiners has been produced in a sealed cover, which makes clear that the aforesaid guidelines of Medical Council of India have been followed by the respondent university. Therefore, this court is of the opinion that the appellant university prima facie has made out a case for staying the operation of the impugned judgment, and it is accordingly stayed. Lords, in fact, it is there in the sealed cover. It's open, lords, for them to have a look at it, whether they had requisite qualification. In fact, in the statement of objection, the university had taken a stand that there is a process by which these examiners are appointed. There's a panel drawn by the university. All these are experienced professors with over 10 years of experience in teaching profession, and they're duly qualified. Now, in the light of this, the question for your lordship's consideration is whether this order, which has, lords, insofar as setting aside the ordinance is concerned, we are not concerned because we have ourselves, lords, replaced it with the ordinance which reflects the MCI regulations. Lords, coming back to the order of the learned single judge. Its point number 2 was in regard to whether there is a variance in the qualification prescribed by the ordinance between the external examiner and the internal examiner. Now, lords, we have demonstrated that the external examiner whom were empaneled had more than 6 years of experience, which is the mandate under the MCI regulations. So therefore, my lords, question number 2 also, my lords, did not require interference at the hands of the court. Ultimately, my lords, the court proceeded. Yes. Yes. No, it would be a futile exercise, because if I have to do it by a competent authority again, the very competent authorities are entitled to evaluate, which they have already done. So it's more an academic issue that. Three or six. For yes. Yes. We have followed that. The division bench lords verified that fact by opening the seal cover and satisfying that it has been done in accordance with the MCI regulations. Now, in the light of that, I asked this question to myself, what purpose would be served? Let's see, other aspect is these are all batch of students of 2019. The first two respondents, my lords, have appeared in subsequent examination and have passed. So also, my lords, there were totally, how many students were there? We have filed a memo. No, they have appeared, but they have failed. Yes, my lords, but no, still they appeared and they have failed again. Yes, my lord. So also some of them passed during the pendency. Yes, yes, they are no longer interested in prosecuting.
Well,
Only-
several of them, my lords, because this is their, for this reason, my lords, this becomes their first attempt. My lords, in several places where they get employed, my lords, their promotion is dependent on whether they pass their PG in the first attempt or not. Even regarding appointment also, my lords, this becomes a qualification, promotion and qualification. For that reason, my lords, all of them are interested to pass in their first attempt, including, my lords, one student who has not yet passed, my lords, and there are several orders passed by the learned single judge post this, my lords, following this order. So they're all awaiting, my lords, outcome of this appeal. Yes, my lords. It is, my lords. My lords, even for promotion, my lords, that is taken into consideration whether, my lords, that particular person has passed in the first attempt or not. Even for appointment as against another person, that is looked into. Yes, my lords. Yes, yes, yes. This is one example, Malos. I'll give another example. With respect to Malos services in the army or air force or otherwise, Malos, this is a specific condition that the student must have passed the examination in the first attempt. Yes. Yes. Both Malos in MBBS as well as in PG. So if he wants to be appointed as a doctor, also Malos that he should have passed the MBBS in the first attempt, as well as Malos for PG Malos that it should be in the first attempt. Only those students are considered and they're not even allowed to apply. If you've taken second or third attempt, they are not even allowed to apply. Not even allowed to apply. So Malos, that becomes relevant question, Malos. Apart this, Malos, I said that this judgment has been followed by in case of other students who are not before your lordships also, Malos, where this order is followed. In all of those cases, Malos, the outcome of this judgment is, Malos, awaited. Malos, that this judgment, Malos, has been followed and allowed. Their writ petitions have been allowed. Separate writ petitions against whom, Malos, appeal. Yes, Malos, subsequent writ petitions. No, Malos, appeal is not filed. Appeal has not been filed. Writ petition has been allowed in favor of the students, but the university has not filed the appeal and not followed the order, awaiting, Malos, outcome of this appeal.
No, lords. Some of them implemented themselves in these appeals.
Some of them have implemented, some of them are still
have-
awaiting. No appeal is filed against any of their orders. Only with respect to this.
This is a.
Yes.
Where is the order which says it is not required?
I would respectfully disagree with that, my lords, and point out to your lordships that may not be so. And my lords, now at this stage, my lords, they have conceded that they have their ordinances are, my lords, in variations. My lords, so now we have to take their word for everything else that they say they have done, because they have not placed anything on record. For this reason, my lords, why, my lords, that cannot be believed. I'll show, my lords, here. If your lordships were to kindly just see, my lords, page number. My lords, might just for a moment see, my lords, page number 164 in the appeal memo, Annexure C. This is the answer script, my lords. Evaluation paper. This does not bear any, my lord, signature of any of the evaluators. This is a digital valuation done by, my lords, at remote places where, my lords, who is doing it is not reflected. There is no, my lords, a code also, my lords, with respect to which evaluator has evaluated this answer paper. So, my lords, there is nothing to show, my lords, that there are 4 evaluators as to which evaluator has conducted the evaluation. Second, my lords, this evaluation is not conducted based on, my lords, universities list that has been placed before your lordships. This was also noted by the learned single judge, my lords, which I'll show. My lords may kindly see this notification, which was placed before the court on by a memo. My lords may kindly see Annexure H, page 199. My apologies. Yes, my lords. The very next page, my lord, Annexure J, 200, page, ink page 200. This was placed before the court during the hearing, my lords. 15/7/2020. My lords has that. Kindly, my lords, I'll just read this notification. Regarding Digital Valuation Center and tagged colleges regarding. With reference to the above subject, the below mentioned colleges are attached to the respective centers as listed below as digital valuation centers by so and so. It's a private body, my lords. Of PG Medical July 2020 examinations. Further, you are directed to inform the chief coordinator and custodians to communicate with the evaluators, only those who are listed in the panel, to your centers for evaluation for the attached colleges. My lords, this is the colleges and the centers. And the principal, my lords, is directed in the last, my lords. This is not a valuation done at the university. This is done at the, my lords, remote centers, my lords, at the institution itself. In the chairmanship of the respective principals, my lords, in the next page, if your lordship were to see page number 6, principal dean of the attached colleges are directed to depute eligible evaluators for digital valuation. Kindly expedite the evaluation so as to facilitate early results. Thanking you. My lords, when the university itself, my lords, in the impugned notification had not, my lords, noticed what is the regulation. Admittedly. My lords, they amended that ordinance, placed it before the court, which also carried the very same mistake. My lords, this was noticed by the court. Even when they did the amendment, my lords, they have made the very same mistake. Having done that and having looked at this, my lords, document where evaluation is not done at the university level, where is the question of, my lords, university my lords, overseeing any of the procedure, saying that yes, regulations have been followed. This is not done at the university. This is done at the remote location. And, my lords, the list that has been placed before your lordships. Yes, my lords, concerned medical college. Where, my lords, the university's notifications are, my lords, already communicated to the principals. Principals are told, my lords, this is a qualification of eligibility qualification of the examiners. And they are directed, my lords, to appoint eligible evaluators. When the university itself has not properly, my lords, notified the required eligibility criteria, my lords, they cannot contend that all examiners were eligible. Because they themselves have not understood what the eligibility is. And, my lords, university, my lords, by the very 2 ordinance. One is the impugned ordinance, my lords. Second is the amended ordinance, which was placed before the court. Secondly, my lords. Yes, my lords.
Valuation actually by default, you can say they follow the effect is adhering to the MRNCA regulations.
Yes, ma'am.
Maybe no intention to follow MCI, but in fact they follow it by default.
Yes, ma'am. Please, ma'am. To that I have an answer, ma'am. What has been placed before your lordships is not, my lords, the list of examiners who have conducted evaluation of the petitioner's answer papers. In the sealed cover. No such information is placed before your lordships, saying these were the 4 examiners who have conducted so and so answer papers evaluation. Yes, they have just listed a panel of evaluators, and we have to assume that, my lords, somebody from that list was appointed. My lords, we do not know. That is why, my lords, that information itself is not forthcoming. in the absence of a cogent information placed before your lordships, cannot be drawn. In light of which, my lords, having the notifications not being, my lords, properly done, I am entitled for conduct of revaluation. My lords, kindly see the direction issued. It's only with respect to the petitioners and not to reconduct the entire examination, only evaluation. Please reconduct the evaluation of the answer papers.
Where evaluated are ABC. And those ABC fulfill the regulations as far as.
Yes.
How?
Yes.
Yes. No, for that, we submitted in seal cover a statement. Could you pass it on to this? What is their sealed cover? Sealed cover is there. It is.
It says it's kept below, my lords, in the cause list itself, that the sealed cover is kept below in the file.
Just supply this. One is internal, one is external.
It's one thing that I should mention to your lordships in the beginning itself, the entirety of these lists, which lords are being shown to the court, are of the evaluators who have been empaneled by the university by an expert body who identifies who are qualified. Now, if your lords are to see their experience, which is the last column, college-wise, everybody is, lords, experienced over 8 and 9 years. Now, my learned friend says, it is not shown to the court that we, the petitioners, papers have not been shown to have been evaluated by competent person. That's his argument. Yes. Names. Yes. Yes, well, I'll answer. Yes. Yes, would your lords kindly take the very first page? The first column is name of the teacher. Yes. The second is designation. The third is the subject. The fourth is the college in which they are teaching. The fourth is, my lords, the address. Fifth is the date of birth, their UG degree, PG degree, and experience. Now, each one of them, the college name which is shown is the college in which this evaluation has taken place. Lords, the center which is identified is kept confidential so that there is no malpractice. So for the sake of convenience of the university, it has identified several centers where the evaluation takes place. There is a empanel list. The person who is in charge of evaluation, the head of the evaluation process, has been asked to identify qualified persons to evaluate under the central system. Now that's how, my lords, the evaluation has taken place. We have no other persons who are not qualified who have been identified as. Yes. 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 Different centers identified by the university. Is it in the college? Ah. Hmm. Okay. Let's. It is identified. My learned friend says that if your lots are to take item 1, Mangala M. Pai, who is the professor in anatomy, has evaluated in Kasturba Medical College. And
Students of this college.
This college. Yes. Let's only apprehension we had was to disclose that a student has been evaluated by B, because that would disclose, and there is a judgment of the Supreme Court which says you shall not disclose.
Since you have information, you are not this called a valuation.
Yes.
Evaluated, you say, what is being expressed means how to establish that in fact this professor has evaluated the candidates of this medical science college unless and until you show the answer sheet.
Very well.
Are you trying to say so?
And yes, my lords, and my lords, the information that is provided is where they are professors, including for external examiners, not where they have conducted evaluation, is my understanding. Absolutely. Is of. Yes, my lords. He has done it or not? Yes. My lords, that, yes.
It's now yeah, I have understood, but then just to clarify whatever doubt he is expressing, Lords may give me a week's time. I will see if it is possible to give it to the court, not to my learned friend, the exact details of which professor evaluated which of these petitioners. My learned friend petitioner's name is known to us. We also know which college he is studying. All I have to do is ask the university to show which of these professors in regard to which subject have evaluated. That will show it to the court, not to my learned friend, but will show it to the court. There's no difficulty. But this is only an argument of no. It can't be, my lords. That is capable of. No. It's not in public, and we don't want to disclose it. We'll leave it to the court. We'll show it to the court, identifying where the petitioner. This list contains all the students of the university. We'll identify the petitioners and show it to the court. There's no difficulty.
But for the NMC, as far as we are concerned, so long as they are able to show substantially, in effect, that they have done it, because our regulation says that X act must be done. So the interluding factor is the ordinance. It's OTOs. It's not even necessary. So if they are able to show, since they were not able to show, we opposed that and got it quashed. That was our submission, but not as seen in the order. If they are able to show, however, then it would amount to compliance with our regulation, and our regulation is what matters. MCN.
Well, sir.
I'm just making a small distinction. So the quashing or otherwise, or the violation of the university ordinance is rendered redundant to the extent that there is compliance with ours, because ours is the overriding. That's the bottom line. So then nothing remains except to factually.
Yes.
So once that is there, then we will also not have any objection. That's right. That's right.
We will query the respondents only. We'll place it before the court. Otherwise, my lords.
Yes, yes.
No, my lords, this is a small number. if we are able to satisfy your lordships that to aid the respondents, we have done it in accordance with law, and that should satisfy my land and should take your lordship's word that it is done in accordance with the requirement. I'll show it, I'll show it to the MCI, my lords. I have no difficulty.
My lords, I
Yes.
would request, my lords, as a officer of the court, my lords, I be permitted to check, not the petitioners, my lords, but the officer of the court as a counsel, my lords, I may kindly be allowed to look at it before your lordships. Please. Great.
Yes, yes, yes. Lords, which different colleges?
Yeah, all different.
Different colleges.
Now, there I would
Let's-
also agree with the university that that should So
Let's-
there I would
they
agree
are-
with the university that it should not be. We have reasons also for that. The list should not be accessible anywhere else except the court. As far as the list of examiners is.
So that issue is covered.
That is much more than the Rafale cover. Man. That is only money. This is a lot more than that. This.
Yes. Looks, they are at different colleges all over the state. To take some time, about 3-4 weeks time. 4 weeks. Yes. Hmm? Oh. Lords, just to oblige me, my lords, could your lords consider saying having heard for some time so that it comes before this court? What?
Great.
5 weeks. I'll go with that.
IAPF, the respondent. Sixth respondent. For Mr. Ashok Naik IAPF. Appellants are not here.
Synapses.
Koti.
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 prepared a brief synopsis also. May I pass on with the leave of the court? Lord, the main contention is this, that I have purchased this property from a village officer in 1970. Subsequently, it was re-granted in his favor as per the full bench judgment of this honorable court. Feeding the grant by estoppel, my title gets perfected. Lord, long thereafter, I filed a suit for declaration of title against the daughter of the person who sold in my favor because he had died. My suit was decreed. She files a miscellaneous application to set aside because she was placed ex parte. That miscellaneous application came to be dismissed. Then an appeal was filed against that. In the appeal, my lord, the learned judge says, let it go back to reconsider the miscellaneous application. Now, my lord, thereafter she sells it to the present appellant, same property. She executes a sale deed. Now, my lord, I go before the Tahsildar and ask for entry of my name in the record of rights because I have a decree which has attained the finality. And subsequent sale, my lord, subject to any declaration by anybody, is a void sale because there is nothing for her to sell. My lord, then the Tahsildar rejects my application on the ground that the ex parte decree was set aside. He did not understand that what was remanded was only to reconsider the miscellaneous application and not the original suit itself. Against that, I filed an appeal to the Assistant Commissioner. Assistant Commissioner understands this particular aspect. He did not accept. And the name of the original owner's daughter continued. Yes. Assistant Commissioner Millard was convinced with my submissions to the effect that the ex parte decree was not set aside. That Millard, he reversed and said, directed the Tahsildar to enter my name. Then a revision petition is filed to the Deputy Commissioner. In the meantime, Millard, the appellant files another suit for declaration of title. The Deputy Commissioner sets aside the order of the Assistant Commissioner and says, subject to result of his suit, the names must be changed. I come before the learned single judge. The learned single judge appreciates my contention and says when there is a decree already in my favor, and this is only a suit which is pending, the learned judge, my lord, as the learned single judge, allows my writ petition and then says, follow the Assistant Commissioner's order and then gives a direction. As against that, the appeal is preferred.
Because this matter was in the list for the last one month, my lord.
Because it is in until disposed of list, Lord, I used to come and wait for this matter. Because sometimes we don't know when suddenly matters, my lord, which we expect to go on, my lord, for some reason gets adjourned, like the one before.
2 acres, 31 tas, only 2 acres.
Daily list daily list
Daily list.
Friday or Monday, Tuesday.
So that one, yeah.
10th, if it can come in the daily list, my lord. Yes. First list. I am grateful. 10th, if your lordship would kindly have it. I don't take more than 10-15 minutes, subject to what he says. Very well, my lord. I am grateful.
Appearing for the appellant, my lord. My lord, we have engaged a senior counsel. My lord, maybe if my lords could have it day after tomorrow. The senior counsel is engaged today. He is not. My lord, we are challenging the order passed by this honorable court in the writ petition, whereby we had challenged a reference that was made before the labor court. We challenged the reference made because the entity did not exist as on the date when the reference was made. And that was the challenge before.
I appear for respondent government, my lord. Respondent government. My lord, Srinivasan, A.J. Srinivasan.
Because my lords, the factory was closed as on date when the reference was. I'm for the appellant, my lord.
It is a company, my lord.
My lord, the reference was made against these respondents. Please. Please. Please, my lord. We have engaged Mr. Srinivas Raghavan for the matter, my lord. He is engaged. He is not available today, my lord. If my lords can have it day after tomorrow. The recordings of the reference are at Annexure B, my lord, at page number 75. Lord, at 72, page number 72, my lord. Please. Please, my lords, we'll make our submissions on the merits on day after, if my lords can have it day after tomorrow. Day after tomorrow, my lords. Please.
My lord, I appear for My lord, I appear for appellant in the regular government advocate of this court is not keeping well, my lord. Hence, this matter may be called day after tomorrow, my lord. Today has instructed me to appear for the reason is unhealthy. That is the reason. Devraj, who is appearing in this case as for government, my lord, is not keeping well today. Hence, it may be called tomorrow or day after. Oh, yes, much okay.
I prefer the appellant in this case, my lord, sir. But kindly have it Tuesday or Wednesday, senior counsel is engaged. He is held up in other court, my lord, sir. Please. But kindly have it in the first list, my lord, sir. Please.
My lord, in this case also, tomorrow it may be taken. Yes, much okay.
I'm on behalf of the appellant, so I'm ready. I'm ready to address. Yes, sir. Your lordships, the issue relating, we have challenged the order passed by the land tribunal, your lordships, at Bantwal, which granted the occupancy right, which granted the right under section 38, read with form 2A of the Karnataka Land Reforms Act, lordships. Lordships, please. Your lordships, the brief facts of the case are, your lordships, we were the petitioner before the learned single judge, your lordship. We have challenged the we challenged Annexure A, your lordships. Annexure A is an order which granted rights under section 38, read with section form number 2A, your lordships. Section 38 of the Karnataka Land Reforms Act talks about the dwelling rights, your lordships. Your lordships, if an agricultural laborer is in possession of a property, the property which belongs to, is ordinarily residing in a dwelling house, your lordships, he would be entitled to claim rights over that property, your lordships, by filing form 2A, your lordships, and an inquiry will be made under section 48A, your lordships, and he would be granted such right, your lordships. That order was made in the year, your lordships, in 2001, your lordships. An application was filed in the year 82-83, your lordships. But in the meanwhile, your lordships, the petitioner herein, your lordships, in the year 1978, your lordships, via an order dated at Annexure B, your lordships. Annexure B on 39th, 1978, your lordships, we were granted occupancy rights, your lordships, where we filed an application under Form 7A, your lordships. Form 7A read with section 45, your lordships. And we were granted occupancy rights, your lordships. The land which is, or the property which is in concern is, your lordship, if your lordships were to go to page number 47, your lordships. Your lordships, there are two survey numbers, your lordships, which concerns to this case, your lordships, where we are disputing or we are asking the court to interfere, your lordships. I believe is appearing for the respondents.
Please, I appear for the contesting respondent. Contesting respondent.
Please, your lordships. Your lordships, at page number 49, your lordships, if your lordships were to 47, your lordships, the schedule is there, your lordships. In the schedule, your lordships, the petitioner number 1, your lordships, the appellant number 1 herein, was granted the occupancy right, your lordships, in survey number 299 of 1B, that is up to 28 cents, your lordships, and 299 of 1E, your lordships, that is 299 1B, your lordships. Your lordships, in page number 47, your lordships. Annexure B, your lordships. In the schedule, your lordships. At the bottom of the page, your lordships. Yes. 299 1B, that is 28 cents, your lordships. And 299 1E, that is 21 cents, your lordships. In the year 1978, I was granted occupancy rights over that land, your lordships. Later, your lordships, according to the same, we got form number 10, your lordships, which granted us the rights over that particular property, your lordships, according to the Karnataka Land Reforms Act. And later, your lordships, we changed the survey number of that particular property were combined, your lordships. That is 299, that is total of 49 cents, your lordships, was made as survey number, your lordships.
Your Lordships, it was converted as survey number 299 1P12, Your Lordships, which is the total extent of 49 cents, Your Lordships. Your Lordships, the RTC regarding this particular survey number 299 bar 1P12, Your Lordships. Your Lordships, the RTC which is produced at Annexure D, Your Lordships, confirms the same, Your Lordships. It has mentioned my name, Your Lordships. Your Lordships, at Annexure D, Your Lordships. Please, Your Lordships. Your Lordships, the Babanna Purusha, Your Lordships, it's at Your Lordships, the translated portion is at page number 52, my lords. That is the possessor or occupant's name or father's name. That is Babanna Purusha, Your Lordships. In column number 9, my lords. Your Lordships, it is survey number 299, Your Lordships. In the survey number, Your Lordships. The total extent is 49 cents, Your Lordships. That is comprising of 28 cents in the 299 bar 1B, Your Lordships, and 21 cents in 299 bar 1E, Your Lordships. It was changed. Please. Your Lordships, in column number 2, Your Lordships, I believe that is missing, Your Lordships. If Your Lordships were to take the original RTC, Your Lordships, at page number 51, my lords. At page number 51, in second column, Your Lordship, it is mentioned as ISA. ISA is 1P12, Your Lordships. 1P12, Your Lordships, ISA. Yes, Your Lordships. It is at page number 53, Your Lordships. So these two properties where Your Lordships were combined and formed a new survey number, Your Lordships. Your Lordships. 1B, 28 cents, Your Lordships, and 1E. Your Lordships, it was again Your Lordships, that record, it's not on record, Your Lordships. Please, Your Lordships. Your Lordships, if I may read out the portion in the writ petition, Your Lordships, where I do say, Your Lordships. Please, Your Lordships. Please, Your Lordships. It was renumbered after the survey, Your Lordships. Your Lordships, I would take time, Your Lordships. Your Lordships, as per my understanding, in the petition, it is mentioned as this, Your Lordship. It was renumbered. Yes, Your Lordships. Yes, Your Lordships. Yes, Your Lordships. Apart from that, Your Lordships, the total 49 cents was in my occupation, Your Lordships, as per the order dated, as I pointed out, at Annexure B, Your Lordships. That is on 13/9/1978, Your Lordships. And Your Lordships, and I was granted occupancy right. Form number 10 was issued in the year 1981, Your Lordships, as per the order made in at Annexure B. That is at Annexure C, Your Lordships. Your Lordships, later, Your Lordships, out of the 49 cents, Your Lordships, I sold, Your Lordships, 21 cents of that particular land in favor of Kanti Jamma, Your Lordships. Out of the old 49 cents, Your Lordships, I sold a land of 23 cents, Your Lordships, in favor of one Mr. Mohammed, Your Lordships. And an extent of 21 cents was sold in the favor of Kanti Jamma, Your Lordships. So the remaining portion was 5 cents, Your Lordships. When the 5 cents was remaining, Your Lordships, I sold it in favor of the second petitioner herein here. That is second appellant herein and the second petitioner before the learned single judge. That is Mohammed Sharif, Your Lordships. And Your Lordships, when Mr. Mohammed Sharif approached the concerned authority to change the RTC names, Your Lordships, he was taken by surprise as to the fact that in the year 2001, Your Lordships, the same 5 cents was granted to the third respondent in the writ petition. And since the third respondent was dead, Your Lordships, our LRs were brought on record as respondent number 3 to respondent number 7, Your Lordships. The land tribunal, Your Lordships. Please, Your Lordships. Your Lordships, first, it was granted to me over the old 49 cents in the year 1978, Your Lordships. And your lordships, at annexure A, your lordships, that is the impugned order under challenge, your lordships. In the year 2001, the 5 cents was granted under, when an application was filed under Form 2A, your lordships, it was granted to the respondent number 3, your lordships, in the writ petition. Without notice to me, your lordships. Yes, your lordships. I have challenged the, your lordships. I have challenged the same in the year 2012, your lordships, because I was not aware of the proceedings which took, your lordships, in the writ petition, your lordships. In the writ petition, your lordships, I have challenged the order at annexure A, which the 5 cents, the order is in the year 2001, your lordships. Please, your lordships, at annexure A, your lordships. Please, your lordships. Without giving me notice, the land tribunal, your lordships, which granted me, your lordships, in the year 2012, your lordships, I filed the writ petition in the year 2. We were not aware of the same, your lordships. Your lordships, because no notice was given, your lordships. Please, your lordships. I was exerting my rights, your lordships, according to your lordships. 5 cents was in my favor, your lordships. I was exerting my right, and in the year 2000, your lordships, is an occupant, your lordships. Your lordships, I was in possession of that land, your lordships, and your lordships, in order to assert their right, the respondent number 3 to assert a right over the scheduled 5 cents, your lordships, she has to establish a right as contemplated in the section 38, your lordships. She should have a dwelling house and she should be in possession of the property, your lordships. I have already asserted my right, your lordships, and an order for me, a grant of occupancy right was granted in the year 1978, your lordships. And they filed a form in the year 1982, my lords, and then it was granted in their favor in the year 2001, your lordships. I was in possession of that land, your lordships, from the beginning, and I have proved my possession. That is why the occupancy right was granted to me in the year 1978 by the same land tribunal, your lordships. Your lordships. That is the distinction which the learned single judge made, and the learned single judge held that since a form number 2A differs from, it does not bar the agricultural labor to get a right over that 5 cents, your lordships. Your lordships, however, your lordships, as your lordships are aware, in case if there is a rival contention, your lordship, or a rival claim which is already settled, your lordships, the general course of action according to section 48A as well as rule 17 of the Karnataka Land Reforms Act, your lordships, it states that whenever a form or application is made for the occupancy rights, your lordships, in case of a rival claim is there, the case which was already decided should be open, and both the rival claims has to be decided and heard together, and an occupancy right or right under Form 2A has to be granted, your lordships. In this particular case, none of it is followed, your lordships. I was granted in the year 1978. I was granted occupancy right, your lordships. Your lordships, I would pass judgments, your lordships, which says that your lordships, which the division bench of this honorable court, your lordships, has held that in case a second application is considered, your lordships. Your lordships, is under paragraph B, your lordships. If the second application is being considered at a later point of time, it would still be necessary to reopen the earlier proceedings and to hear both the claims together, as otherwise the earlier order would be technically a bar, your lordships. Your lordships, the learned single judge held that Form 2A is different from Form 7. Even though Form 7, you have exercised your right, Form 2A, still the agricultural labor as the right, or as the right under Form 2A to get dwelling house rights, or as rights under Section 38, your lordship. However, a notice has to be given, your lordships, according to Section 48A, your lordships, where there are two rival claims, your lordships, and the case must be reopened, and then the learned tribunal has to give a notice to me because I am an occupant of the land, your lordships, and then the learned tribunal has to decide, your lordships. In this particular case, no such notice was given to me, your lordships. And therefore, your lordships, we challenge this right. And further, your lordships, when an occupancy right is granted, your lordships,
I have one submission. My lords, this contention was raised before the learned single judge. There was, my lords, argument was put forth. Learned single judge, my lords, had, my lords, directed the government advocate to get the entire records on the ground that, my lords, in paragraph number 3 of my statement of objections, I have raised a contention saying that the form 10, what they are, my lords, harping upon, is not in existence. My lords, the entire records were called for before the learned single judge, because, my lords, I myself I had appeared before the learned single judge. My lords, there was no form 10. My lords, I had raised this contention in my statement of objections itself. Yes, yes. Form 10 itself was not available. My lords, I had raised this contention. Yes, yes. That's why, my lords, entire records were called for, original records.
order is there, your lordships.
That
Order is-
annexure C, my lords, we had disputed. We have
Lordships.
disputed that annexure C in my
The order is at annexure B, your lordships. Form 10 was issued, your lordships. It's at annexure C, your lordships. It is there, your lordships.
That itself I disputed, my lords.
We have
Because entire typed copies were produced along with the writ petition. There was no original records or Xerox copies. Hence, my lords, I had disputed that. Certified, my lords, there was no certified copy also. There was no certified copy. Hence, my lords, my lords, disputed that. Of annexure C, my lords, there is no certified copy.
Please, your lord.
These are the typed copies, my lords, which were produced before the learned single judge. My lords, page number 49. 49 and 50, my lords.
Your lordships, it was in my favor. That is the copy, your lordships. In
That
form
is, my
number-
lords,
It was.
yes. My lords, I filed, my lords, the application. The original owner, my lords, the owner that they are claiming for, and my, my lords, owner, that is, my lords, one Ganapati Bhatt, who is a family member. He had filed a writ petition saying that, my lords, the entire property belongs to them. Hence, my lords, he has challenged my, my lords, grant also. There is. Please. Yes. Label, please, please. Yes. Please. Please. But I filed declaration on.
In 82-83, your lordships.
Please.
Your lordships in 2001. Your lordships, in fact, your lordships, the same Ganapati, but who the learned counsel for the respondent referred to, as disputed his claim over the property, your lordships. That his claim,
Yes,
claim.
that
He
came to
says
be rejected.
his-
He had filed a writ petition, my lords. Maybe, my lords, yes. Yes. that itself is my case, my lords, that land was not granted to him. Otherwise, my lords, Ganapati Bhatt would have challenged his my lords, grant also. He did not challenge his grant. My lords, my case itself is, my lords, original Form 10 is not there. Hence, that is not granted to him. I'm the only, my lords, person who has been granted this 5 and 4 cents of land. That is one of the reasons, my lords, entire the form number 10, my lords, we dispute that there is no such form number 10 on the ground that, my lords, this annexure R1 endorsement issued by the my lords, authority. Annexure R1 is at page number 93, translated copy at page number 95. I, my lords, filed an application under RTI. The authority says, my lords, entire records have been sent to the High Court. Hence, my lords, learned single judge, my lords, called for the record by the government advocate, and my lords, that was verified.
Your lordships, at 100 and
My application under RTI regarding Form 10.
the respond.
My lords, page number 90.
No,
Yes.
your lord. 2A is
Lords,
filed by them.
2A, yes. My lords, my filed a RTI application, my lords, seeking for the entire forms. That is not there. Please, my lords, enter for. Yes, that's why, my lords, it was called for to check whether that form is there or not. It was not available.
Your lordships, in fact.
My lords, my form was there. His form is not. No, my lords, the entire file is maintained by the authority, my lords, which were called for. Regarding the entire land, my lords, it was called for. One file it was.
Your lordships, at page number 113, your lordships, as your lordships pointed out, that is form number 10, which is produced as R6 by the respondents themselves, your lordships. It says my name, your lordships, that is Babanna Purusha.
That is filed along with the memo by you. That was filed along with the memo.
Please. They are disputing only the form number 10, your lordships, which is just a formality, and order, no, your lordships, order we have, your lordships, at annexure,
That is order, my lords, way back in the year 1976. 78 months.
that is the order which granted me occupancy right. Please, your lordships. Yes, your lordships. Yes, your lordships. Please, your lordships. Your lordships, I would. And that is form number 10. Please, your lordships. Your lordships, I would seek to, please, I will furnish it, your lordships. I'll furnish it.
Let them first furnish, because I have seen the original records myself. My lords, then, my lords, I'll have to see the documents, then I make my submission, because from day one I've been disputing that. All of a sudden, my lords, with respectfully, my lords, I'm submitting. It was not there in the original document. Please. Different. Please. 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 Then at the most, minutes, matter has to be remanded back to verify minutes and taken up together.
That
can be the.
That is my alternative submission, your lordships.
That can
First,
be
I
done.
claim my right.
But after lapse of minutes, 2.5 decades, they approach the court minutes very belatedly. They are saying minutes, they were not aware of it. my grant. It was challenged after, my lords, 13 years. My lords, my submission is, my lords, my landlord would be, my lords, notified, not the third person, because then, my lords, the document was not, my lords, available before the authority to say that it's been granted. Please. My lords, I'll need to verify from this. Please. One. I'll have to verify on that. Yes. I had contested that preparation also. Yes. I need to verify on that. Yes. If, my lords, his name was reflecting from day one, my lords, then even, my lords, I would have, my lords, informed the tribunal. Tribunal should have, my lords, informed the appellant also. That is, my lords.
That is an alternative prior revision. Please, Your
It's-
Lordships.
I have one request, my lords. Let them produce the certified copy, my lords. Thereafter, my lords, before, my lords, remanding the matter, my lords, let them, my lords, produce this before this honorable court. That goes to the crux of the matter. My lords, I disputed that. I disputed, my lords, that. I disputed that, my lords, because it was not available in the original records. My lords. My lords, in case if, my lords, there was no document produced or my owner has not, my lords, informed the tribunal. My lords, I was not aware, my lords, about his grant, no doubt, my lords, but my landlord should have, my lords, at least informed. By then, my lords, my application was pending before the tribunal. Please, 5 and 4 cents, my lords. Of course, 4 cents, my lords, he's not,
I'm
only
not
5
disputing
cents.
about the 4 cents.
One. Because, my lords, writ petition was pending by then, my lords, my owner had filed a writ petition here. So both, my lords, were fighting for that. That was also pending, my lords. Landlord must.
Your Lordship, it was against the same landlord, Your Lordship. It was
Same lord. It's the same, my lords, Ganapati Bhatt who was, my lords. It's the same, my lords, person. Mr. Ganapati Bhatt was the person, my lords, who contested the writ petition as well as, my lords, my lords, his, my lords, he did not challenge. Yes, he, my lords, I am not aware, my lords, whether they have, my lords. In mine, my lords, definitely he was notified, but in his case, my lords, I am not.
He was notified, Your Lordship. If Your Lordships were to, yes, Your Lord, the owner of the land was notified, Your Lordships. Is stand, Your Lordships, I'm not aware of is stand. However, Your Lordships, the rules as contemplated under section 48A was followed, Your Lordships. And he was notified, he was made as respondent number, please, Your Lordship. Your Lordships, I was granted the occupancy rights again over his land, Your Lordships. That is where his title over his property will come to an end, Your Lordships. Your Lordships, in fact, the same Narayana, but which the learned counsel for the rest.
Minutes.
Your Lordships, the fact.
He had minutes, I'm told minutes, he had challenged the same minutes, the grant which was in my favor.
The original.
On various minutes. Minutes, this writ petition is minutes, the order which was minutes passed by the tribunal. Minutes granting me the 4 and 5 cents of land. Both were challenged. He contested the matter minutes, thereafter he filed a writ petition. No minutes, that was dismissed.
Your Lordship, if I make a.
His writ petition was dismissed, please. He did not challenge minutes that has attained finality.
If I may make a submission, Your Lordships, the Narayan, but who the respondent are claiming is himself told that I was not the owner of the property, Your Lordships, in their proceedings, Your Lordships. And his son was, who filed the writ petitions challenging the order which was passed in the year 2001, which gave them the right, Your Lordships. Please, Your Lordships. His son, Your Lordships, not the same Narayan, but his son, in fact.
Ganapati Bhatt is his son.
Ganapati Bhatt is the son, Your Lordships. In fact, the that to Your Lordships, the saying that the Narayan Bhatt has said that it's not my property. $70. Please. Please.
Uh, 2001.
They filed a.
My application was, yes. Please. He challenged. Please. Please. Minutes, that one thing minutes I need to verify. Minutes in case if you happen to show any to.
In. Please, Your Lordships, that Your Lordships, I pray for time. It is whole 49 cents is what it is in the record, Your Lordships. Your Lordships, I have produced it at Annexure D, Your Lordships.
That is.
No, yes, Your Lordships, that was Your Lordships in the year 2012 RTC, Your Lordships.
That is 12 minutes. That is pendency of from the day of.
During that time, Your Lordships, I pray for time, Your Lordships, that I will have to secure, Your Lordships. Even in the year 2012, it had shown my name, Your Lordships, that is Bhavana Purusha.
Please. Please.
Please. Much of it.